ಒಂದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್. ಮಧ್ಯಾಹ್ನ
It's a 24
With-
matter, my lord.
With your lordship's kind leave. My lord,
Kannur sir, wait a minute, wait a minute. Just a minute,
yes,
just a minute. Yes, sir. ಆಯ್ತು ಕೊಡ್ರಿ ಇಂಟರ್ಲಾಕ್ಟರಿ ಕೊಡಿ ಅಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಿ ಯಾರ್ದು? Who is holding a fresh memo? Fresh memo. ನಾಳೆಗೆ ಆಗಲ್ಲ, ಮಂಡೇ
My lord.
ಎಲ್ಲ ಮಂಡೆಗೆ ತಗೊಳ್ರಿ.
My lord. Third point is, my lord, third point is, my lord, made this honorable court, my lord, the third party came up before this honorable court, my lord, made this honorable court to pass the order.
ನಿಮಗೆ ಏನ್ ಅಲ್ರಿ ನೀವು
My lord, interim order vacating, my lord, I am filing because not the.
ಕೊಡ್ರಿ. ಮಾರ್ಕೆಟಿಂಗ್ ಅಂತ ಹೇಳಬೇಕು. Don't argue and spend waste.
My lord.
Yes,
Writ petition of
Date,
year
date.
2020.
ಕೊಡ್ತಾರೆ ಡೇಟ್ ಕೊಡಿ.
Writ petitions of the year 2020, the LRs have to be brought on record. The petitioner is dead. In fact, a memo was moved without a submission. Malas, some date was given last week, but it has not come up. Malas, may kindly have it on Monday. Malas, there is only a short point. That's
For what? What is the matter?
Malas, the matter is there is a violation of land grant rules under Rule 25. And Malas, my grant has been cancelled. Sheer violation of the provision. Malas,
2020 matter.
2020 matter. Malas. Maybe
ತೋಡ್ರಿ.
on Monday, Malas, my request.
Order, we'll assign it. We'll give it.
A date was given and it has not come up. Malas, last week a date was given on.
Date was given.
Date was given.
ಕೊಡ್ರಿ, Tuesday, Wednesday ಕೊಟ್ಬಿಡಿ.
My lord, it is 24 matter. They are violating the interim order and.
ನೋಡ್ರಿ, fresh matter.
Kindly, 24 matter, yes, ma'am. Kindly have it on Saturday.
My lord.
Fresh matter, hand over.
Sir, respondent is discharged, my lord, as interstate, on RFA matter, sir. The expired, my lord. So proposed amendment, ಆಗ್ತಾ ಇದೀವಿ. So notice to issue ಮಾಡ್ಬೇಕು, sir. 2012 matters.
ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲ. ಬರುತ್ತೆ ಅದು ಬರುತ್ತೆ. Don't move.
One matter, well, the impleading applicant filed in a public.
So what do you want? Fresh matter?
It's not a fresh matter, the urgency is great respect, matter. The problem is this. Well, there is a division bench order to demolish the building and take the position to the government. Well, suppressing the fact before this honorable court and is the petitioner filed a request and obtained the stay order. There was a division bench of this honorable.
Who are you and who are you?
Well, I have filed the public litigation before the court number 1. That petition, after reading the both the sides, this the honorable court was allowed the petition, directed the government to take the position of the property.
Order ತೋಡ್ರಿ ಅದು.
Then, my lord, without
Preliminary ಹಾಕ್ತೀವಿ.
ಯಾವ್ದಾದ್ರು ಪರವಾಗಿಲ್ಲ. I filed an impleading application. ಅದು 2 year ಅನ್ನ I1 ಅಂತ ಬರಬೇಕು.
ಇದು preliminary ಪೋಸ್ಟ್ ಮಾಡ್ರಿ. ಬರ್ದ್ಬಿಡ್ರಿ ಮೇಲ್ಗಡೆ.
Implead ಯಾವ್ದಾದ್ರು ಪರವಾಗಿಲ್ಲ. ಅದು ಸಿಂಗಲ್ ಇದೆ ನೋಡಿ. ಟ್ರಿಬಲ್ 1 ಇರೋದನ್ನ ಇದು ತಗೊಳ್ಳಿ ಸರ್. ಫಸ್ಟ್ ಒನ್ ಇದು ತಗೊಳ್ಳಿ. ಇದು ಎಸ್ ಸರ್, ಈಗ ಹೇಳಿದ್ದು. ಅದು ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಏನಂದ್ರೆ, they have filed an application. The problem is this, my lord, due to delay of getting the order, my lord, there is a problem. ಅದಕ್ಕೋಸ್ಕರ ಅದು ಇನ್ನೊಂದು ಯಾವ ಡೇಟ್ ಆದ್ರೂ ಕೊಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಎನಿ ಡೇಟ್.
Yes, sir.
ಡೇಟ್ ಹೇಳಿ ಸರ್, ಇಲ್ದ ಇದ್ರೆ ಬರಲ್ಲ, ಬಹಳ ಕಷ್ಟ ಆಯ್ತು. ಪಾರ್ಟಿಗಳು ಜಗಳ ಆಡ್ತಾ ಇದಾರೆ ಬಂದು, ಆ ತರ ಪರಿಸ್ಥಿತಿ ಆಗಿದೆ ಲಾಯರ್ಗಳಿಗೆ. ನಾಟ್ ಓನ್ಲಿ ಫಾರ್ ಮೀ.
Order, sir.
ಅಲ್ಲ, ಎನಿ ಡೇಟ್ ಯಾವ್ದು.
ಹಳೆ ಮ್ಯಾಟರ್ ರೆಡಿ ಆಗಿ ಬರ್ರಿ.
ಹಳೆ ಮ್ಯಾಟ್ರ್ ಅಲ್ಲ, ಹಳೆ ಮ್ಯಾಟ್ರ್ ಎಲ್ಲ ಇದೆ ಸರ್. ಇದು ಎಲ್ಲ ಇದು ಹಳೇದೇ, ಇದು 2020.
ಕೋರ್ಟಿಗೆ ವಕೀಲರು ಬರಲ್ಲ, ಸುಮ್ನೆ ಹೇಳ್ಬೇಡಿ ಏನಾದ್ರು.
ಅಲ್ಲ,
Date will be assigned. Don't tell them.
Lordship,
ಯಾವ date
covered by matters, my lordship. Last time by mistake, ಬೇರೆ ಕೋಟಲ್ಲಿ post ಆಗಿ ಅಲ್ಲಿ date ಕೊಟ್ಟಿಲ್ಲ, my lord. At
Yes,
least
sir. Kannur, sir.
next week of.
my lord, yesterday, my lord, I apologize, my lord, I was not there. My lord, it appears Venkat Reddy, who is the contesting defendant in these first appeals, my lord, where it appears, my lord, that he has to argue today, and he has, I'm informed that he's present in the court. So he would argue today, my lord. Then, my lord, tomorrow I will, my lord, then reply, my lord, once he completes.
ಇದಾರೆ, ಇಲ್ಲೇ ಇದಾರೆ. ಅವರೇ ಡಿಪೆಂಡ್.
ನಾಳೆ ಅವ್ರಿಗೆ ಯಾವತ್ತು ಬೇಕು ಅವತ್ತು, ನಾಟ್ ಇವನ್ 5 minutes.
ಆಗಲ್ಲ Kannur, sir.
ಫಸ್ಟ್ ಪರ್ಚೇಸರ್ we have sold. So that is nothing.
Wait a minute. Had you informed yesterday, I would not have listed it today. I'm not taking other matters.
Yes,
Already.
no, my lord. Now the only. So
Sir.
tomorrow, my lord, once he completes tomorrow, I will argue, my lord, your lordship, I will start my argument. I had to come to Dharwad High Court, my lord, parted my.
No, I had informed your instructing counsel. Then you should have informed me not to list it today. I would have listed it on Friday. Why your instructing counsel didn't brought to my notice that you will not be there? All right. ನೀವು ಮಾಡ್ತೀರಾ ಇವತ್ತು? ಇಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡಿಬಿಡ್ರಿ.
Let him come.
ಇಲ್ಲ, ಒಂದು ನಾಟ್ ಇವನ್ 5 minutes because first purchaser and then we have sold it.
All right. I will hear you and you close your side today. All right.
Yes, then I'll reply tomorrow. I'm sorry, my lord, I'll come in.
What, sir? What, Kannur, sir? At your instance, I took up this matter and you're not ready to argue.
No, no, my lord, I'm ready to argue, my lord. I had come yesterday to argue. If your lordship
ಆಯ್ತಾಯ್ತು, ನೀವು
recalls-
ನಾಳೆ ಮಾಡಿ.
ಅಲ್ಲ, if your lordship
Tomorrow,
recalls, my
tomorrow.
lord, 18th ಗಂತ ತಾವು
ಆಯ್ತು,
17th
you argue tomorrow.
ಬಂದಿದ್ದೆ ನಿನ್ನೆ ತಮ್ಮ ಕೋರ್ಟಿಗೆ.
You argue tomorrow. Yes.
Please.
Question
on serial number 1, Savita.
Yes.
Adjournment. I appeal for the petitioner, my lord.
Yes, madam.
On the last occasion, I was directed to
Harish.
file the affidavit. I have already filed the affidavit along.
I have to get
Alright, this-
instruction, my lord.
Today is a civil day, madam.
Please, my lord,
Here, madam.
just because the date was given, it is listed today. My lord, one more submission. ಇದ್ರ ಜೊತೆ ಇನ್ನೊಂದ್ ಮ್ಯಾಟರ್ ಇವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದೆ, ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇತ್ತು ಅದ್ರಲ್ಲಿ, ಇಟ್ ಈಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್
I will
ಟುಡೇ.
extend it on to the next date. I will extend it.
ಅಲ್ಲ 19th ಅಂತಾನೆ ಡೇಟ್ ಇದೆ ಕನೆಕ್ಟೆಡ್.
Registry is directed to tag this writ petition along with WP number so and so.
Number 2.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
ಅದ್ರಲ್ಲಿ ನಾನು ಆ ದಿವಸ extend ಮಾಡ್ತೀನಿ, madam.
ಪ್ಲೀಸ್
I will extend interim order on the next date.
ಪ್ಲೀಸ್
Bring to my notice.
ಪ್ಲೀಸ್
Yes, next.
ಪ್ಲೀಸ್.
I prefer the petitioner, my lord. The petitioner seeking the mandamus to the third or fourth respondent to restore my name in the revenue record, my lord.
Yes, madam.
Granted land,
ವಿಲ್ ಲುಕ್ ಇಂಟು.
ಮಾಡ್ಬೋದಾ?
interim order, my lord, they are insisting the village accountant and the revenue inspector, my lord, they every day come to the land and insist not to made any agricultural activities, my lord.
Huh?
Any agricultural activities, not to made any agricultural
Why,
activities.
why?
This is because, my lord, the mutation entered in the as government.
ನೋಡಿ, ಇದು ಹೊಸ ಕಂಪ್ಲೇಂಟ್ ಇದು. It's a kind of a complaint, madam.
Yes, madam.
I've never come across a village accountant
Yes.
interfering with a owner, lawful owners.
I'll instruct me, because the
Yes, yes.
mistakes committed by
The
part
otherwise-
of the revenue authorities only this happened. In spite of the special DC has made an observation that land belongs to the petitioner only, but mistook the.
AC also set
Want me
aside
to
the
take action
MR
or
entry,
is-
subsequent MR entry. Yes, please.
Will you convey it to him that he can't do it? Will you convey
I
to
will
him,
instruct me.
instruct him
Yes,
not to interfere?
yes, ma'am.
Work order. Caption petition is filed. Seeking mandamus against fourth respondent to restore petitioner's name in the revenue records pertaining to survey number 173/P10 of Maranalli village, measuring 39 guntas. Next. The subject matter of the petition land was admittedly a Goma land. Petitioner submitted an application before Bagarukum committee seeking a regularization of 2 acres in survey number 173. The committee, the land grant committee, after due inquiry under 108 of Karnataka Land Revenue Rules 1966, recommended to regularize petitioner's unauthorized occupation. Consequently, Tashildar has issued a Sagoli Chitta grant.
Yes, my secretary, sir. Committee has granted.
Has issued a Sagoli Chit, which is evident
Mutation entry
by
has
order
also
dated
entered.
22/9/1997. Petitioner has deposited the requisite upset price amount demanded by the authority. A mutation also came to be effected under MR number 2/9798. Next paragraph. The deputy commissioner suspecting that petitioner's grant is secured fraudulently initiated suo motu proceedings under section 136(3) of Karnataka Land Revenue Act. On inquiry, deputy commissioner however found that the grant in favor of petitioner
Yes, my lord.
was based on a valid recommendation by the land grant committee, and also found that that the Tashildar has issued a grant certificate which is preceded by a recommendation under Rule 108D of 1966 rules. Deputy Commissioner, after conclusion of the inquiry, has dropped the proceedings which is evidenced at Annexure G. Next paragraph. Petitioner is aggrieved by the inaction on the part of
On the basis of same order, my lord, he has mutated the name in the annexure H, my lord.
Ah.
Kindly see, no, on the basis of the same order, whether the special deputy commissioner passed in favor of me, saying the same order, kindly see the annexure H. The basis of the mutating the name of the government is the annexure G. Page number 55, my lord. Annexure H.
Yes.
ಅದು ಹೇಳ್ತಾ ಇರೋದು ಮುಟೇಶನ್ ಸರ್ಕಾರ ಅಂತ ಬರ್ದಿರೋದು RRT ನಂಬರ್ ಸೊ ಡೇಟೆಡ್ 9/12/2000 ವಿಶೇಷ ತರಿಸಿದ್ರೆ ದ ಸೇಮ್ ಆರ್ಡರ್ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 9 as part of the commissioner ಮೇಲೆ in favor of us. On the basis of the same order, the mutated the name of the government.
Instead of your name, instead of restoring your name.
Yes, my lord. No, not restoring, my lord. Name of the government, restoring the name of the government.
Based on an order passed at annexure
Yes,
G.
my lord. That mutation order challenged before the AC, my lord. AC has set aside the mutation entry of the subsequently made and direct the Tahsildar to restore the name of the my petitioner's name, my lord. That is annexure J, my lord.
Based on annexure G,
Annexure G, he has mutated the name of the government.
those
Yes.
proceedings are dropped.
Yes, yes, proceeding. Even though, my lord, proceeding the draft.
You challenge it before.
Yeah, the challenge before the AC, my lord. AC has set aside and direct the Tahsildar to restore the name of my name, my lord. Annexure J kindly be seen, my lord.
That is J.
Annexure J, my lord.
Work order. Though the proceedings were dropped by deputy commissioner, which is evidence at annexure G,
Yeah, annexure J, my lord. Tahsildar.
the
Annexure H, my lord.
fourth respondent Tahsildar,
On the basis of.
though takes cognizance of the order of the deputy
Yes,
commissioner,
definitely.
but still proceeds to mutate the name of the state
State.
in the ownership column. Petitioner feeling aggrieved by the impugned mutation. What MR HR 32 ala
Yes, that is appeal filed brother before the AC, my lord.
/ 2014-15 preferred an appeal under 136(2) before third respondent assistant commissioner. Assistant commissioner has set aside this mutation
Yes, my lord. And directed.
and has directed fourth respondent Tahsildar to restore the names of the petitioner to
Yes.
the petition land. Next, though there is a direction by third respondent assistant commissioner, which is evidenced at annexure G,
One
J,
second,
J.
AC has also directed, my lord. Annexure K, since order passed more than 4 years, he has not taken any action.
J.
Annexure K may be seen, my lord.
annexure J, and a communication dated 23/2/2018 addressed by assistant commissioner
Yes,
to
ma'am.
Tahsildar, ward annexure K, there is a complete laxness on the part of
ಸದರಿ ಪ್ರಕರಣ ಆದೇಶವಾಗಿ
fourth
3 ವರ್ಷ 10
respondent-
ತಿಂಗಳಾಗಿದ್ದು
fourth respondent Tahsildar in not restoring the petitioner's name to the RTC pertaining to the petition land. Next, the action of fourth respondent clearly is found to be contrary to the inquiry conducted by second respondent special deputy commissioner as per annexure G. This court has also noticed that that fourth respondent, contrary to inquiry conducted by annexure G, taking cognizance of this very said order, strangely deletes the name of petitioner and enters the name of the state to the RTC. This action is clearly illegal and capricious. Assistant Commissioner in an appeal under 136(2) has not only set aside this mutation certified by fourth respondent Tahsildar, but has sent a communication on 23/2/2018, evidence that annexure K, directing fourth respondent Tahsildar to restore petitioner's name. These significant details clearly reflect the conduct of fourth respondent Tahsildar and also indicates that there is a clear dereliction of duty on the part of fourth respondent Tahsildar. Though this is a fit case to initiate action against fourth respondent Tahsildar, having regard to the fact that Leonard AGA has assured this court that petitioner's name will be restored to the RTC pertaining to the petition land, this court this court, giving a benefit of doubt to fourth respondent Tahsildar, proceeds to pass the following order. Writ petition is allowed. Fourth respondent is hereby directed to forthwith restore petitioner's name in RTC pertaining to survey number 173/P10 of Marnalli village, so and so. Next, this exercise shall be accomplished within a period of 4 weeks from the date of receipt of order copy, failing which the matter will be viewed seriously and appropriate action shall will be initiated against both respondents. Tahsildar.
2 months, 8 weeks.
6 weeks.
Appeal number 3, Manjunath Devi.
Mandamus, my lord. The formation of tar road or RCC,
Formation of?
formation of tar road, my lord. And Kacha road ಇದೆ, ನಕಾಶೆ ರಸ್ತೆ ಇದೆ.
Is it there? Is it a part of village map? Madam,
Yes, please, please.
where are the records?
Annexure B, my lord, page number 10.
Madam, seek instruction in this matter. Better. We don't know. Learned AG is directed to accept notice to respondents.
1 and 2.
1 and 2 ಮಾತ್ರ private respondents ಇದಾರಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಬರೀ ಡೈರೆಕ್ಷನ್ ಅಷ್ಟೇ, ನಾನು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಸರ್ಕ್ಯುಲರ್ ನಮ್ಮ ಹೊಲ ನಮ್ಮ ದಾರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಅದು
ಅದನ್ನ
ನೋಡಿ.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
We'll pass it today or we'll pass it on the next day?
Monday ತಗೊಳ್ಳಿ ನಾ ಹೇಳ್ತೀನಿ.
Please.
Preliminary on Monday. Next.
Appeal number 4.
In this case, I'm appearing for the petitioner in this case, madam.
ಏನ್
But
ಮಾಡಿ?
in this case, we are challenging the order passed by the first respondent dismissing my appeal. We are challenging the entries in RTC made in favor of the fourth respondent, my lord.
Now this land is standing in his whose name?
My lord, originally the land belongs to one Hanumaka. Now the fourth respondent, without having any right over the property, she has produced 2 documents. One is transfer certificate, another one is death certificate of deceased Hanumaka. Both the certificates have been forged. The concerned authorities have issued an endorsement saying that, not kindly see the page number.
Already, and who are you?
I am the legal representative of.
How are you related?
My lord, kindly see the first document wherein the petitioner's father has been adopted son of the deceased Hanumaka.
Hanmaka.
Yes. And the first document itself, the page number 40, this is the registered will, wherein it has clearly stated that one Anjanappa is the adopted son of Ningaya and Hanumaka. And the suit scheduled property, scheduled property is not mentioned in the registered will itself, the court has not considered that he is not the adopted son. But only
This registered will is in whose favor?
registered will is in favor of petitioner's father.
Father.
But their contention is the scheduled property is not mentioned in the said will. It is pertaining to other property which
Other
belongs to.
property.
But Lord, why the scheduled property is not mentioned in the said will is at the time of execution of the registered will, the property was before this deputy commissioner for consideration. Therefore, it has not been mentioned in this register. My lord, kindly see the fourth respondent. Only based on the RTC entries, she has produced 2 forged documents before the
Alright,
Tahsildar.
you both go to the court and establish your right. Till then, Hanumaka's name will be restored.
That's what.
One
Please.
submission.
How are you related?
One, I am the adopted daughter. One submission, madam.
Show
This-
the adoption deed.
One submission. This land, my lords, they are claiming revenue entries. My lords, it was acquired by the BDA. Now, my lords, we filed the LAC proceedings. Out of the LAC order, my lords, an order came to be passed saying that parties have to go to civil court and establish their rights.
Correct.
This order is already passed. Against which order, my lords, MFA is filed. It is pending consideration. My learned friend, my lords, is appearing in that matter also. That, my lords, is slated to be
Alright,
listed on
still you
15th.
have to be relegated. Under mutation proceedings, you have to be relegated to civil court.
We are only seeking one to restore the original. allotment.
Or you await the judgment.
My lords, since the matter is now pending,
Till then, on the mutation side,
Yes.
no, my lords, nobody is claiming compensation. Compensation will not be given to us. It will not go to them, neither to them, nor to me.
Alright.
Nobody is claiming
but
compensation.
let.
Let the amount not be dispersed.
Now,
But
the
you can't-
RTC stands in the
Wait,
name of.
Wait a minute.
Yes.
Wait a minute.
Let the compensation amount, my lords, on the award by the BDA, let it not be dispersed to anybody. Let it
We are
be,
not deciding that also.
that is
not
the issue,
before-
my lords, which is pending.
That is not before me. You convince me how you are entitled to get your name mutated under 128. Based on a transfer certificate.
That, my lords, I'll file my objections, my lords, I'll place it on record.
No objections.
My lords, I'm on caveat, my lords, this coming for the first.
No statement for this case.
My lords, I am the adopted daughter.
Where is the registered or adoption deed?
Registered document, my lords, is not there.
Better don't take a finding on that issue in a mutation proceeding. Now, who ordered to mutate your name based on a transfer certificate?
On
Yes.
150, page number 150
No,
is
no,
the mutation.
Nishant,
My lords.
you get the name mutated based on a transfer certificate? Transfer certificate ಮತ್ತಿನ್ನೇನು?
ಎರಡು.
ಅದೊಂದೇನಾ?
Transfer certificate to death certificate of deceased Hanumaka.
It's death certificate of deceased.
Alright.
Deceased.
I'll not express anything on merits, but you have to be relegated to civil
Yes.
court. Or you work out your remedies in a pending miscellaneous first appeal, all right?
Please,
Work out. Now, Tahsildar mutated your name,
please.
whether he was heard, you objected this
Yeah,
person?
objected before the Tahsildar ASN.
What are the orders of assistant commissioner and deputy commissioner?
They are
say
reversed
that-
against me.
No.
No, they
that-
said only
they
said-
say- They say that MFA is pending. Therefore, after adjudication of that,
128 vote. Then how they could have mutated your name and await and direct the parties to
no.
await a
AC,
judgment?
my lords, the learned assistant commissioner said that since the matter is pending before the civil court,
Ah.
await the decision of the civil court, which was
You should have
confirmed.
set aside- You should have set aside that mutation. Work out.
For a moment, on please, madam. Page number 82, please.
Ah,
Page number 82, please.
80,
82.
ಏನಿದೆ 82 ಅಲ್ಲಿ?
Transfer certificate ಅಲ್ಲಿ the institute, head of the
But as
institute
adopted daughter.
ಅಂತ ಸೇರ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಡ್ಮಿಷನ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್. ಅಲ್ಲಿರೋದು ಒರಿಜಿನಲ್ ನೇಮು ಹೇಮಲತಾ ಅಂತ. ಇವರು ಆ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ BO and he has suggested forgery ಮಾಡಿದ್ದಾರೆ ಅಂತಾರೆ. Thereafter, before the BDA, they have initiated and FIR has been lodged and the fourth respondent has been arrested.
No, no,
He is
no.
in judicial custody.
No, no, no. my
ಅಲ್ಲಲ್ಲ,
lords.
ನಾನು
That
ಅದಕ್ಕೆ
is a
ಹೇಳಕ್
wrong
ಹೋಗ್ತಾ ಇಲ್ಲ.
statement, my lords.
Only the original name has to
All
be
the
restored.
criminal
That's all.
proceedings, my lords, are
Till the-
stayed by this
I've
one.
already expressed and why you're arguing.
ಅಲ್ಲಲ್ಲ.
The court has already expressed.
Please, ma'am. Sorry.
Work out. Caption petition is filed assailing the impugned mutation effected by third respondent Tahsildar, thereby mutating the name of fourth respondent to the petition land. The said order was assailed by petitioner by way of an appeal under 136(2) before second respondent assistant commissioner. Second respondent assistant commissioner referring to the pendency of miscellaneous first appeal
Please, my lords.
in MFA number
MFA number, my lords, is 1827 of 2023.
1827 of 2023, relegated the parties to work out their remedies in a pending appeal before this court. The said order is confirmed by first respondent deputy commissioner. These concurrent orders are assailed by petitioner hearing. Next, the counsel for petitioner and London counsel opinion for respondent number 4. There is no dispute that the petition land was originally owned by one Hanumakka, wife of Ningaya. They said Hanumakka
Died issueless.
acquired this property through a grant,
Yes.
Please,
through a grant, through order of grant dated 14/1/1957. The Tahsildar, the then Tahsildar, while order dated, while 2/4/1969, confirmed the grant conferred on Hanumakka under the land grant rules. Next paragraph. Petitioner asserts that he is the adopted son of Hanumakka and the same is evidenced in the will executed by Hanumakka in respect of other lands, and then therefore asserts that he has inherited the property left behind by Hanumakka and is entitled to get his name mutated. Next, fourth respondent equally is also asserting to be adopted daughter of late Hanumakka
and I dispute his adoption.
and is disputing petitioner's adoption. The subject matter of the land is acquired by
Bangalore Development Authority.
by Bangalore Development Authority, and the compensation is determined. And the dispute as to who is entitled to receive the compensation is pending consideration before this court in MFA number no, so and so. Next, on reviewing the records, this court is of the view that petitioner and fourth respondent are not entitled to get their name mutated unless they are able to substantiate and establish their relation and right over the petition land. petitioner is asserting, petitioner and fourth respondent, both are claiming to be the adopted child of late Hanumakka, unless their status is established in a properly instituted proceedings before a competent civil court. The revenue authorities heard in entertaining an application tendered by fourth respondent. Third respondent Tashildar had no jurisdiction to take cognizance of a transfer certificate indicating that the fourth respondent is the adopted daughter of the late Hanumakka. The claim of fourth respondent, unless the same is substantiated and established before a competent civil court, no right is acquired which would compel a revenue authority to effect change in khata by exercising jurisdiction under section 128 of Karnataka Land Revenue Act 1964. Next paragraph, this court, the parties to the petition have not placed the records relating to acquisition and pendency of the appeal before this court. This court is not aware of the nature of proceedings pending in miscellaneous first appeal. The petitioner and fourth respondent have to either substantiate and establish their right in a pending miscellaneous appeal, or have to approach the civil court and establish their right and status and how they are entitled to inherit the property left behind by Hanumakka. It is in this background, this court is of the view the third respondent heard in effecting mutation and thereby entering the name of fourth respondent by placing reliance on a transfer certificate. The said mutation, impugned mutation, wild annexure. I have placed it on record.
Yes, please.
Wild annexure.
Annexure.
Mutation, my lord,
My lord,
page 150.
T, annexure T, my lord.
Annexure
MR
T.
number 13 of 22.
The consequent orders passed by second respondent, wild annexure so and so, and first deputy commissioner, wild annexure so and so,
MR
are not sustainable and are liable to be quashed by this court. For the foregoing reason, this court passes the following order. Writ petition is allowed. The impugned mutation.
Annexure T.
So and so, as per annexure T, and all both the orders are hereby quashed and set aside. The third respondent Tashildar is hereby directed to restore the name of Hanumakka, which shall be subject to outcome of the pending miscellaneous first appeal before this court. Yes.
Please. All,
Or
let
yes.
all contentions be.
All contentions are
Kept
kept
open.
Sir, because my lords, the finding that the
Miscellaneous
transfer
petition.
certificate is a forged
No, no.
document, my lords.
that I have not
My
decided.
lord, one submission, miscellaneous petition, apart from the miscellaneous petition, the outcome of the civil court of, who is the LRs of the legal representative.
Early they are
Nobody has
Well,
gone to civil.
miscellaneous
If he-
ಅಲ್ಲಿ
if he is going to
both
civil.
don't want to go to.
ಅಲ್ಲ ಮಿಸ್ಲೇನಿಯಸ್ ಅಲ್ಲಿ LAC ನಲ್ಲಿ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟ್ ಯಾರು ಅಂತ ಹೇಳಿ ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. That has not been challenged before the miscellaneous. Even in the miscellaneous
He-
ಅಲ್ಲಿ
he
this
has to
court
go to
cannot
civil.
consider the who is the LRs of the.
You advise your clients. Even your client have to go and file a suit, sir.
Yes, please. You have
You have not done.
ಇಲ್ಲ ನಾವು ಹಾಕಿದ್ವಿ.
ನಾನು ಅದಕ್ಕೆ ಬರ್ದಿದ್ದೀನಿ ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೀನಿ. Both have to go to civil court.
Please.
ಇದೇನು ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಮಾಡಲನ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆಯಾ 30 ಕೆಳಗಡೆ
30-31 ರೆಫರೆನ್ಸ್
30-31
ಜಡ್ಜ್ಮೆಂಟ್ ಆಗೋಗಿದೆ.
reference.
ಅದ್ರ ಮೇಲೆ MF.
In the 30-31 reference,
that is not placed before me.
Yes, yes.
that is that miscellaneous first appeal. I'm grateful.
Next.
Number 5, SK Acharya.
ಯಾವುದು? Yes, sir.
The on number 7A proceedings, some of the family members, they question the proceedings before the KAT, 16 years delay, in filing the appeal before the KAT. The revenue members, in paragraph 1, he has condoned the delay and remanded. the
80
matter.
ಮುಂದೆ what order was challenged?
Order was challenged by the, this annexure, my lord.
ಅಲ್ಲ, that order was under what provision?
77A, my lord.
Oh.
ಅದರಲ್ಲಿ 16
You are the landlord,
one line ಅಲ್ಲಿ they condoned the delay and allowed the appeal.
Who are you? You are the tenant?
I am the tenant, my lord. The owners have challenged the appeal. Order is of the year 2006, my lord. 2022 ನಲ್ಲಿ appeal ಮುಂದೆ KAT ಮುಂದೆ appeal ಹಾಕಿದ್ರು.
By the landlord.
Landlord. Notices were, several parties were there. There was no proper notice, procedure was also not taken. I was not,
Wait a minute.
yes, I did not defend the appeal
You filed
before.
objections to the delay application?
Well, I did not prosecute the appeal before the KT mail for want of the service of notice, proper notice on the proper address, my lord. Appeal mail unilaterally came to be accepted by my lord, one line order.
That there is no proper service.
My lord, I have taken, my lord, kindly look at this, my lord. It is simply stated.
What addresses are indicated in the
Well,
appeal?
address indicated, my lord, some villages has been given, my lord. Kindly, the appeal memo kindly be seen by annexure B, my lord, page 28.
28.
Yes, my lord. Respondents of residents of Nandikuru village. That's all. No,
ಯಾವ್ದು actual ನಿಮ್ದು ಯಾವ್ದು?
ನಮ್ಮದು ಬೇರೆ, ನಮ್ಮದು ಇಲ್ಲಿ ಅಡ್ರೆಸ್ ಹಾಕಿದ್ದೇನೆ. ಆಮೇಲೆ ಸಾಂತೂರು ಬೆಳ್ಳಿಬೆಟ್ಟು ಗುತ್ತು, ಸಾಂತೂರು ವಿಲೇಜ್, ಪಿಲಾರ್ ಪೋಸ್ಟ್, these are the proper address. ಅಲ್ಲಿ ಸಿಂಪ್ಲಿ ಸಾಂತೂರು ವಿಲೇಜ್, ಉಡುಪಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು. And appeal my lord has referred to the Mangalore camp. I was not aware of the proceeding. Kindly look at this.
ನಂದಿಕೂರು ವಿಲೇಜ್ ಅಂತಿದೆ.
ಹೌದು, ಇದು ಸಾಂತೂರು.
ಬೇರೆ address.
Separate village.
Work had the counsel for petitioner. Learned AG is directed to accept notice to respondents 1 and 2. Petitioner who is a tenant.
Yes, tenant.
Tenant and
Form number 7A.
Who is a tenant and is conferred with grant of lands under section 77A by Assistant Commissioner. He is aggrieved with the order passed by the appellate tribunal. Evidence that annexure A. The primary objection raised by the petitioner before this court is that the appellate tribunal, without verifying whether the notices are served to petitioner, has entertained a belated appeal when
16 years.
When admittedly there is a delay of 16 years. It is also submitted to this court that private respondents have consciously and deliberately given a wrong address in the appeal memo, and without serving notice, inordinate delay of 16 years is condoned, and the order passed by the Assistant Commissioner granting land to the petitioners is reversed by the appellate tribunal. Prima facie, this court is satisfied that there is no proper inquiry, petitioners were not notified, and inordinate delay of 16 years is condoned by the appellate tribunal without assigning cogent reasons. Matter requires consideration. Accordingly, the order under challenge is stayed until further orders.
Please.
Issue emergency notice to respondents
Respondents, my lord.
3 to 15.
Yes, my lord.
Yes.
My stay of my lord, further proceeding before the inquiry there in yellow.
ಇದು ಸ್ಟೇನೆ ಮಾಡಿದ್ದಲ್ಲ ನಾನು.
ಹೌದಾ, ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹೇಳ್ಬಿಟ್ಟು
ಪ್ರೇಯರ್ ಏನಿದೆ?
ನಾನಲ್ಲಿ ಸ್ಟೇ ಅಂತಲೇ ಕೇಳಿದ್ದೇನೆ.
ಮಾಡಿ ಆಯ್ತಲ್ಲ.
ಮಾಡಿ ಅಲ್ಲ, ಅಲ್ಲಿ ಎಂಕ್ವೈರಿ ಮುಂದೆ ಹೋದ್ರೆ ಮತ್ತೆ ಸ್ಟೇ ಇಲ್ಲ ಅಂತ ಅವರು ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಆರ್ಡರ್ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ.
ಮ್ಯಾಟರ್ ಹ್ಯಾಸ್ ಬೀನ್ ರಿಮೈಂಡೆಡ್ ರಿಮೈಂಡ್ ಆಗಿದೆ.
ಓ, ರಿಮೈಂಡ್ ಆಗಿದೆ.
ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
stayed. Show it to the.
I will stay.
Ali has allowed the appeal and the matter is remitted back to Assistant Commissioner.
Appear for the petitioner in this matter. The petitioner is the grantee. The land has been granted. He was doing under Bagarukumam Sagavali in the year 1994-95.
Yes,
That is annexure B, Swami.
What's the relief you are seeking before this court?
See, ಏನಗಿದೆ ಅಂದ್ರೆ it was a Sarkari Pada in the year 1939 and 1940. That land has been granted to the petitioner in the year 94-95. That the revenue entries were mutated in his name, annexure C. So, and he is in possession and enjoyment of the property.
Order December 2023 order.
ಹೌದು ಸ್ವಾಮಿ. ಏನಾಗಿದೆ ಅಂದ್ರೆ we prepared an appeal before the deputy commissioner. Deputy commissioner has confirmed the order of the AC, that AC has set aside the grant made in my favor. So 1939-40 ಪಡಾನ in the year 2021 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ತಾರೆ ರಿಡಿಮ್ಷನ್ಗೆ. That we are the legal heirs of so and so ಅಂತ, except RTC, no other document, one affidavit filed by them that we are the legal heirs of.
What is the date of grant in your favor?
94-95.
And now that grant is recorded at the premises that that Pada is reversed anta.
ಹೌದು.
But it was a case, it belongs to my family, my lord, is not in dispute.
Correct.
Not the entire extent of land, my lord, was earlier granted to us. My lord, at an earlier certain point of time, my lord, for non-payment of taxes,
Correct.
revenue record came to be entered. But
Forfeiture
there
is
is no
not permissible.
forfeiture order. There is no record, my lord, indicating that possession has been taken over by the government.
Who is in possession right now?
We are in possession of the property.
Yeah,
They have
it-
filed a suit for permanent injunction, my lord, before the Dodlapur court, my lord, it is pending consideration. It is in OS 92 of two thousand
You
twenty-four.
have the benefit of interim order at the hands of the
They do
court?
not have any interim order before the trial court,
No, no. Suit is filed by them
filed by them against me.
against you.
I would like to make a submission.
Not,
Now, what is the total extent?
not
3
total
acres.
extent is 9 acres, 17 guntas.
9 acres.
9 acres, 17
What is
guntas.
granted is only 3 acres to
Yes.
them out of 9 acres.
2 acres, 17 guntas, my
I
lord.
think, madam, December 2023 order, you file statement.
Please.
Allala, Swami, in the meanwhile, what has happened? If my order is, see,
Fact,
he has
correct.
set aside the grant when the right was being
Madam,
divested in the.
Madam,
See, he has no right, title or interest over a
December
property.
2023 order, madam.
Sir, yes, the Deputy Commissioner order is 25/6/2024. At annexure L.
You had a benefit of interim order before deputy commissioner. Interim order itta nim parvagi.
There were 2 writ petitions that came to be filed by two
Common
parties.
address. Common
The other
address
writ
being
petition,
passed by the Deputy
Madam,
Commissioner.
you had a benefit of interim order.
I
before
I would
deputy-
like to submit Your Honor, when the right title or interest has been given to the occupancy rights in favor of the petition herein, that cannot be disturbed by virtue of he paying the pada amount pay ಮಾಡಿದ್ದಾರೆ. Annexure H ನೋಡಿ ಸ್ವಾಮಿ. What is the prayer of the respondent number 1? ಇರ್ತೀನಿ. Annexure H. Prayer portion. Petitioner prays that this honorable court authority please to set aside the or cancel the grant made of 1994-95 made by the first respondent in favor of respondent 214 in extent of 3/4 acres 24 guntas. There he never sought that
We'll examine the grant order, madam. We'll examine the cancellation of grant order. It requires.
ಇವಾಗ ನಾವು ಯಾರ್ ಇಸ್ ನಾಟ್ ಸ್ಟೇಡ್ ಅವರು ಮುಟೇಶನ್ ಮಾಡಕ್ ಬಂದಿದ್ದಾರೆ ಮಧ್ಯರಾತ್ರಿನಲ್ಲಿ ದೇ ಹಾವ್ ಬಾಟ್ ವಿತ್ ದಿ ಸರ್ವೆ ಅಥಾರಿಟೀಸ್ ಇನ್ ದ ಮಿಡ್ ನೈಟ್ ಈಸ್ ರಿಸೈಡಿಂಗ್ ನಿಯರ್ ಕಣ್ವೆ ಯಗಡಿಹಳ್ಳಿ ನಿಯರ್ ನಂದಿ ಬೆಟ್ಟ ಈಸ್ ರಿಸೈಡಿಂಗ್ ಇನ್ ದಿ ಲ್ಯಾಂಡ್ ಈಸ್ ಎ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಹೌಸ್.
Documents, see.
I have produced all the documents, Panis, mutation, everything, grant certificate issued in my favor. I am in possession and enjoyment of. the
Protect your
property.
possession in a pending suit. You file appropriate application and seek injunction.
If I don't challenge this order, what will the effect of that? He will restore the pada anta order ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Pada ಅಂದ್ರೆ even though he has not sought for the restoration of pada, cancellation of the idu, stay the proceedings.
ನಿಮ್ಮಿಂದನೇ ಇದೆಲ್ಲ litigation ಆಗಿರೋದು ನಿಮ್ಮಿಂದ.
Pada melod, it's a pada.
Sir, after lapse of 80 years, they have come up with this contention.
But it's not a government land. There should be an order of forfeiture under section 87 and 88 of the Karnataka Land Revenue Act. All that the all that the Tahsildar can do is
Record the tax.
that's all.
Alla Swami.
He has to auction the property and recover towards arrears of land revenue.
Sir, but if a right is created, what is the date of grant in their favor?
Not- They say it is in the year 1994. It is without notice to me. I was not made a party.
Why you should be made a party when it was already? notified
A
as a-
portion of the property was
There is
already,
no forfeiture, there is no forfeiture order.
there is no forfeiture order. That is the
Only
observation
mutation.
that has been made.
Sir,
There are no
after
government
80
records indicating
years,
possession has been taken
he
over.
has stepped over for 80 years
No.
and he comes up with the only one document that Sarkari pada. He
Madam.
says, ನಾನು ಒಂದ್ ನಿಮಿಷ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ.
Madam, one ನಿಮಿಷ, you have to answer the court questions. You just can't go on arguing.
ಆಯ್ತು.
ಪಡ ಅಂತಂದ್ರೆ ಏನು? Does he lose his right? Title ಹೋಗತ್ತಾ ಪಡ ಅಂತ ಬರೆದ್ರೆ?
ಆಯ್ತು ಸ್ವಾಮಿ, ಒನ್ಸ್ ದೇ ಹಾವ್ ಮೇಡ್ ಎ ಬಕರ್ ಸಾಗುವಳಿ ಚಿಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ they could have challenged that order if he was really in possession and the cultivating
What
the
right you
land.
will get? What right you will get on based on the Sagoli chit issued? by
So
the
ಬಗರ್ ಸಾಗುವಳಿ ನಾನು I
It-
was cultivating.
It's without jurisdiction. There has to be forfeiture, madam.
What is the limitation
all
for
right, you-
challenging the order?
Just a minute. You answer one court question. Whether there is a vesting? Vesting ಆಗಿದೆಯಾ? State
ಹೌದು,
ಹೋಗ್ಬೇಕಲ್ಲ.
I am in possession and enjoyment. I am cultivating the land over there.
It's a patta land. It's a patta land. Show me that there is a vesting. Under what provision there is a vesting? How does this land vest with the government? Under what order?
ಆಯ್ತು ಸ್ವಾಮಿ, there is a limitation for everything. and he doesn't, his ancestors, his great father never challenged the order. He comes in the year 2021 after lapse of 24 years of
Leonard.
grant in my favor. ನನ್ನ ಹೆಸರಿಗೆ 24 ವರ್ಷ ಆದ್ಮೇಲೆ they come and there is a procedure to follow. And
Leonard,
that has not been followed by the deputy
you want
commissioner.
me to reject your interim order? You,
Alla, you kindly grant me.
shall I reject your
sir.
interim order, madam? Leonard AG is directed to accept notice to respondents 1 to 3. You accept notice, Mr. Reddy, sir?
Fourth respondent have entered caveat.
Only fourth respondent.
Only
Uh,
contesting
What
respondent.
about other respondents?
There are no other respondents, only 1 to 4.
They have compromised the matter, they have withdrawn the.
In fact, the copies that has
Appeal,
been
appeal.
served on me indicates there are only 4 respondents.
No, there are 5 to 10.
I have amended, sorry, ಕೊಡ್ತೀನಿ ನಾನು amended.
I issue emergency notice to respondents 5 to 12. Leave this matter in B group.
Sir, kindly grant interim stay, they will
Sorry,
dispose me, Swami, from
Sorry,
the.
madam. Sorry, madam.
Alla, they will dispose me from the property.
Sorry,
Swami.
madam. You have already filed an injunction suit. Go and protect it. All right, next.
Alla, if the revenue interest is.
You want an
mutilated,
injunction at the hands of a writ court, huh? You've already filed a bail suit.
Stay
for-
the order of the.
Madam, you have already
state
filed a bail suit for injunction. We'll examine whether cancellation of grant is in accordance with law. We will not protect your possession in writ proceedings. You have already filed a bail suit for injunction. Work out your remedies there. Next. 7.
My lord, as per the Karnataka Appellate Tribunal judgment, the name of the petitioner have to incorporate in the revenue records. Instead of incorporating the petitioner name, my vendor grandson name is incorporated in the revenue records, which one Shaikh Hussain Saab sold in favor of H.N. Munibairappa. H.N. Munibairappa in turn sold in my favor. And thereafter, after initiation of section 17 in AB order, which I challenged before the Karnataka Appellate Tribunal, the Karnataka Appellate Tribunal allowed my appeal and set aside the orders of the Assistant Commissioner and sent back the records and judgment to the Assistant Commissioner to incorporate my name in the revenue records.
Now the grandson of original vendor gets his name.
Yes, my lord. Again, my vendor grandson. Vendor, one Shaikh Hussain Saab grandson incorporated in the present RTC. Shaikh Hussain Saab sold in the name of H.N. Munibairappa.
Which is that order where your name is deleted? Your
Well,
name was mutated to the RTC?
My lord, I purchased the property from H.N. Munibairappa. First, Shaikh Hussain Saab is the owner of the property. That is at page number, I kindly see the sale deed, my lord, which I produced, page number 28.
I'll note, but it's synopsis I'll hear.
Synopsis ಅಲ್ಲಿ Shaikh Hussain Saab sold the property in favor of H.N. Munibairappa. H.N. Munibairappa in turn sold in favor of in the name of petitioner. Meanwhile, there is a initiation of proceedings, section 17 and A and B. I am affected person. I challenge the same before the appellate tribunal. And appellate tribunal passed a judgment at page number 41.
RTC ಅಲ್ಲಿ ಯಾರ ಹೆಸರಿತ್ತು? ಇದು forfeiture.
Shaikh Hussain Saab ಹೆಸರಲ್ಲಿತ್ತು.
ಈಗ ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ
ಗ್ರ್ಯಾಂಡ್ ಸನ್ ಹೆಸರಿಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಬರ್ಕೊಂಡ್ರಿ. Had the counsel for petitioner, Leonard DG is directed to accept notice to respondents 1 to 4. Petitioner ಯಾರು mutate ಯಾರು ಮಾಡಿದ್ರು? ತಹಶೀಲ್ದಾರ?
ತಹಶೀಲ್ದಾರ್, third and fourth respondent.
And that is confirmed by both the assistant commissioner and why you have not filed a revision before deputy commissioner?
Well, it is not an order of the, because it is only on the basis of the appellate tribunal judgment, the assistant commissioner have to incorporate my name instead by removing the state government.
His name is not shown in the entry. After purchasing also, his name not been shown in the.
What relief you sought now?
One prayer is that consider my representation as per the Karnataka Appellate Tribunal to incorporate my name, and as well as the incorporating in the name of grandson of the Shaikh Hussain Saab, that is a prayer.
Why don't you prefer an appeal as provided under the Land Revenue Act? Why you directly come and file a
My lord, it is not an order of the 136(2), my lord. It is a communication, since as per the amendment of the Karnataka Land Reforms Act, my lord. The order at annexure A, my lord, in view of the amendment of the Karnataka Land Reforms Act, he continued in the name of my vendor grandson name, my lord.
ಯಾರದು mutation ಮಾಡಿದ್ದು ಯಾರದು?
Fourth respondent, my lord. That is a Vishesha Tahsildar. In the annexure A, it shows.
The direction of the.
Then you filed an appeal before assistant commissioner.
No, my lord, it is the orders of the assistant commissioner only. The communication.
Communication, my lord. What is.
My lord, my kindly say.
You ಮಾತಲ್ಲೇ ಬೇಡಿ ನೀವು. You ಮಾತಾಡ್ಲೇಬೇಡಿ.
Please.
Your officers are adding up litigation like anything.
ಇದರಲ್ಲಿ
Day
communication.
in, day out. One action and it generates 3 to 4 litigations because of your officers. ಬರ್ಕೊಡ್ರಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮೇಲೆ submission. It's only communication. Thereafter, the Tahsildar changed the entry. Therefore, my lord, he has to challenge the same
Not
entry
required.
before the assistant.
Already I'll record reasons. What to do?
Because his name is not incorporated earlier. Earlier, it was not incorporated in the RTC.
Correct, he is a subsequent purchaser, he is the last transfer.
Therefore, my lord, once again, he has to approach the assistant commissioner with the record. He will verify. Then he will direct them to change the entry, my lord.
Harish, unless fifth respondent name is not deleted,
Yes, ma'am. Therefore,
can't be done.
Therefore, my lord, he has to approach the.
Tell me why your officer has mutated the name of fifth respondent.
Because, my lord, he has to approach the AC and give a documents, my lord.
Alri, a Sheikh ಅವ್ರ ಹೆಸರಿತ್ತಲ್ರಿ.
ಕೊಟ್ಟಿಲ್ಲ, ಇಲ್ಲ ಇವ್ರ ಹೆಸರು ಬರ್ಲಿಲ್ಲ. ಮುನಿ ಭೈರಪ್ಪ ಯಾರ ಮುನಿ ಭೈರಪ್ಪ ಅಂತ ಇವ್ರು ವೆಂಡರ್ ಹೆಸರು ಇರೋದು, ಇವ್ರ ಹೆಸರು ಬರ್ಲೇ ಇಲ್ಲ ಇಲ್ಲಿವರೆಗೂ.
ಮುನಿ ಭೈರಪ್ಪ ಅವ್ರ ಹೆಸರಿತ್ತಾ?
ಇತ್ತು. ಅದಾದ್ಮೇಲೆ ಇವ್ರ ಹೆಸರು ಬರ್ಲಿಲ್ಲ. ಮುನಿ ಭೈರಪ್ಪ ಅವ್ರ ಹೆಸರು ಇದೆ, ಇವ್ರದ್ದು ಹೆಸರು ಇದೆ.
Already ನೀವು then how can you go beyond Muni Bhairappa? How can you look further back
ಅದಕ್ಕೆ
beyond Muni Bhairappa?
ಕೊಡ್ತಾರ ಅವರು. ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ತಗೊಂಡು ಕೊಡ್ತಾರೆ. ಡೈರೆಕ್ಷನ್ ಮೇ ಬಿ ಇಶ್ಯೂ ಮಾಡಿ.
No, ಅದೇ you want him to file appeal under 136(2) before adjournment. Where, what is the communication by?
Well, I submitted a representation, my lord. As per the Karnataka Appellate judgment, even also the tribunal also sent records along with judgment, my lord, in the year 2016 itself, my lord. Also, I submitted one more representation.
The order of the assistant commissioner.
Assistant commissioner annexure A, my lord.
ಏನದು annexure?
ಅದ್ರಲ್ಲಿ ಏನಂತಂದ್ರೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ವಿಶೇಷ ರಾಜ್ಯಪತ್ರ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಶಾಸನ 13/7/2020 ಅನ್ವಯ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಕಲಂ 79A ಮತ್ತು B ಅಡಿ ಪೂರ್ವಾನ್ವಯ ಸರ್ಕಾರದ ಪರವಾಗಿ ಆದೇಶವಾದ.
This order is wrong. Assistant commissioner directs to mutate the name of fifth respondent.
ಪ್ಲೀಸ್ ಅದಕ್ಕೆ ಯಾಕೆಂದ್ರೆ ಇವ್ರ ಹೆಸರು ಇರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಈಗ ಇವ್ರು ಹೋಗಿ ಅಲ್ಲಿ ಅಪ್ರೋಚ್ ಮಾಡಿ ಕೊಟ್ರೆ they will do.
ಬರ್ಕೊಡ್ರಿ.
I already approached, my lord.
At the counsel for petitioner, learned AG is directed to accept notice to respondents 1 to 4. The case on hand clearly depicts the misuse of power by second respondent assistant commissioner. The records prima facie reveal that the petition land was originally owned by one Srimati Mukambi. She, along with the children, conveyed the property under registered sale deed in favor of one Sheikh Hussain on 11/5/1984, who in turn sold to one Muni Bhairappa.
Sheikh Hussain Saab, my lord.
Sheikh Hussain Saab, Muni Bhairappa under registered sale deed dated 26/1988. Pursuant to purchase by Sheikh Hussain Saab, proceedings were initiated against
Sheikh Hussain Saab only.
Saab under section 79A and B. Second respondent ordered for forfeiture. While order dated 29/6/1996. Muni Bhairappa, who had purchased from Sheikh Hussain Saab, questioned the order of forfeiture.
You in turn sold in my favor, petitioner favor. I challenge the order.
Then sold the petition land to the petitioner under registered sale deed dated 1/3/2002.
Yes, my lord.
Petitioner, having purchased the land, came to know that there is already an order of forfeiture against his vendor's vendor,
Yes, ma'am.
and therefore he preferred an appeal before the Karnataka Appellate Tribunal.
At annexure D, page
Set aside the order of forfeiture.
At annexure D, page 41.
Next, if these significant details are looked into, fifth respondent, who is the grandson of
Sheikh Hussain Saab.
Mr. Sheikh Hussain Saab, who has already sold this land to Muni Bhairappa, who is the petitioner's vendor, submitted an application to mutate his name. Second respondent assistant commissioner, without taking cognizance of conveyance, Henry.
My lord, it's a 2021 order, my lord. They have given a representation in their 2024.
ಅದೇ ತಪ್ಪು ಏನಿದ್ರು ತಪ್ಪು.
ತಪ್ಪು ಅದಕ್ಕೆ ಇವರು ಅಪ್ರೋಚ್ ಆಗ್ಲಿಲ್ಲ.
ಆಗೋದು
earlier, approaching
ಇರ್ರಿ ಒಂದ್ ನಿಮಿಷ
before earlier.
ಇರ್ರಿ ನಾವು
Please.
ಎಲ್ಲ ಅನ್ಯಾಯ ಮಾಡ್ತಿರ್ರಿ ನೀವು.
Wrong ಇದೆ.
Your officers are capable of
Wrong
handing
ಇದೆ.
out injustice.
Wrong man, it may be wrong, but.
Wait a minute, wait a
We will
minute.
consider this.
No, wait a minute.
Please.
ಏನ್ ಬದ್ರಿ? ಏನ್ ಬದ್ರಿ? No, fifth respondent claiming to be a grandson of Sheikh Hassan Saab has got his name mutated pursuant to direction issued by second respondent assistant commissioner. Fifth respondent's grandfather, namely Sheikh Hassan Saab, has already sold this land to one Muni Bairappa, who in turn has sold this land to the petitioner. Therefore, the impugned mutation pursuant to direction issued by second respondent assistant commissioner is clearly in contravention of the sale deeds executed, which are indicated in the caption petition, and therefore matter requires consideration. Though petitioner has the efficacious remedy of revision before deputy commissioner, this court is of the view that this court is inclined to take cognizance of the illegal order passed by second respondent assistant commissioner. Matter requires consideration. Accordingly, execution and operation of the impugned order so and so stayed pending consideration of the caption petition. Issue emergent notice to respondent number 5.
Great.
All right.
My lord, due to some inconvenience, seniors is not unavailable, my lord. It may be taken up next week, my lords.
All right. At the request of counsel for petitioner,
Much obliged.
list it on so and so date. ಇದರಲ್ಲಿ sir, you are directed to secure instruction.
Please, madam, secured.
Very rare. And what was the direction?
In this, my lord, I secured the,
Order, we'll have it next week. Budwara, list it in preliminary on Wednesday.
today is posted for, to dismissal of the, R. Srinivas Gowda appeared on that day, madam. Yeah, they have challenged the order dated to 1987, my lord. They have not questioned anywhere. 1987,
ನೀವು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೀವು ತಾವು ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕು.
Please.
ಅವ್ರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತೊಗೊಂಡ ತಕ್ಷಣ ತಾವು ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕು. ನಾನು ಇಲ್ಲಿ ನೋಡಿದೆ ಡೆಫರ್ ಆಗಿದೆ, ದೆನ್ ಐ ಕುಡ್ ರೀಕಲೆಕ್ಟ್.
Please. 1987, they have not preferred any appeal, my lord. On the license of delay, my lord.
Next week.
All right, you have done your job. Nothing wrong with that.
Saturday, it may be.
Saturday ಬೇಡ, ಮಂಡೇ ಹಾಕೊಡೋಣ. List it on Monday. Next.
Much obliged.
Mine, I have paid for petitioner, my lord.
Who are you?
My lord, my lord, parties to this petition, my lord, have challenged the partition suit, and partition suit has been decreed. My lord, page number 24 is a compromise petition where parties have filed compromising their dispute, my lord.
And the suit was for what?
Suit for a partition, my lord.
Partition.
I am a family member, one of a family member, my lord. Page number 24 is a compromise petition, my lord. Para 2, my lord. May I, my lord?
Page
24, my lord, annexure C.
whether private respondents are party to this compromise?
Yes, my lord. One of respondent number 4 is a private respondent, my lord.
And what about others?
Others are the government, my lord. My lord, mutation of the land is the question, my lord. Present
Yes.
petition.
What happened after compromise?
My lord, compromise has happened. I would permit to read, my lord. Para 2, my lord, where ದಾವೆಯಲ್ಲಿ ವಾದಿಗಳು ತಿಳಿಸಿರುವಂತೆ ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು 1 ಮತ್ತು 3 ರವರು ಪ್ರತಿವಾದಿಗಳ ಸಂಬಂಧಪಟ್ಟ ಸರಿಯಾಗಿರುತ್ತದೆ ಮತ್ತು ದಾವೆಯ ಸೊತ್ತು ಒಟ್ಟು ಕುಟುಂಬದ ಪಿತ್ರಾರ್ಜಿತ ಸೊತ್ತಾಗಿದ್ದು ಎಂದು ಒಪ್ಪಿರುತ್ತಾರೆ. ಕುಟುಂಬದ ಮೂಲ ಕರ್ತರಾದ ಅಲ್ಗಯ್ಯರವರು 4 ಜನ ಗಂಡ್ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ಮಾರಣ್ಣ, ಹೊಂಬಾಳಯ್ಯ, ಜಾಲಯ್ಯ, ರಾಮಚಂದ್ರಯ್ಯ. Ramachandraya is a present petition, my lord. The petition is against Marana, my lord. Marana is also deceased. Ramachandraya is also deceased. Hence, their wives are the present petitioner and respondent number 4, my lord. My lord, page number 26. As per the compromise petition, my lord, the survey number 27/2 has been allotted. ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ ಹೈನು ಜಮೀನು ಹಾಗೂ 1 ಎಕರೆ 10 ಗುಂಟೆ ಟು ಮಾರಣ್ಣ, my lord. Along with 2ನೇ ತಾಕು 32.08 ಜಮೀನು ಫಾರ್ ಮಾರಣ್ಣ, my lord. Subsequently, my lord, page number 28, my lord, that schedule D falls to the share of present petitioner, my lord. That is Bengaluru Dakshina Taluku Tavarekere Hobli Dodderi Gramada survey number 27/2 ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 32.08 ಗುಂಟೆಗಳ ಹೈನು ಹಾಗೂ 1 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನು ಖರಾಬು.
Under the compromise,
Yes,
these
my lord.
petition lands are allotted to you.
Yes, my lord.
Now, what is the order and the challenge?
Order and challenge is ACs and ACs, my lord. Before that, my lord, what has happened now, my lord? Now, as per the compromise, the mutation has not taken place, my lord. The share has, they have taken 4 acres to the share, leaving my 1 acre 20 Karab land to be Karab, my lord. And now the present petition is challenged, my lord. My lord, annexure, page number 23, my lord, RTC. Previous RTC, I would show, my lord. 9 acre is a total extent, my lord. 9 acre, 19 guntas of land is a total extent of a land, out of which 3 acres is A Karab, my lord. Remaining is 6 acre, 19 guntas, my lord. 2 acres falls to their share, 2 acres falls to my share. 1 acre, 10 guntas, 1 acre, 10 guntas falls to each shares are A Karabs, my lord. They files a appeal before AC, my lord, at page number 21, my lord. 20 is the first page, my lord. 21 is the they files, my lord. There, my lord, the allotted share is 4 acre 0.2 guntas to their share. Mine is 2 acres 32 guntas, whereas my Karab land, A Karab has been converted to B Karab, my lord. That's the difficulty, my lord. That is not followed the compromise petition, my lord. And the reasoning is this, my lord, if my lord permit, my lord. 2019-20 ಸಾಲಿನ ಪಾಣಿ
ಪಟ್ಟ ಲ್ಯಾಂಡ್ ಅಲ್ಲೂ ಕಮ್ಮಿ ತೋರಿಸ್ತಾರೆ.
Yes, my lord.
You were allotted what extent?
My lord, I was allotted 2 acres 32 guntas of Ainu land and 1 acre 10 guntas of Karab land.
All right, forget about Karab right now. 2 acre
32 guntas, my lord.
cultivable.
Yes, my lord.
And now they have reduced this extent.
No, my lord. They have given me 2 acres 32 guntas of cultivable land. But the Karab land is A Karab, my lord. I could apply for conversion to Ainu land.
Correct.
Now that A Karab has been converted to B Karab, my lord.
Under the compromise, there is a division in respect of that A Karab.
Yeah, yes, my lord.
How much you are entitled under the compromise?
My lord.
A Karab land?
Equally, my lord. 1 acre 10 gunta, my lord.
1 acre 10 gunta.
Yes, my lord.
What is the total extent of A Karab land?
3 acres, my lord.
3 acres.
Yes, my lord.
Now they have entire A Karab is allotted to private respondent.
Private respondent and the remaining Karab, what they say is B Karab, my lord. And now they are trying to develop the land, my lord, in the pretext of the AC order and DC order. DC says, my lord, they have applied for conversion.
Who has effected this mutation?
My lord, AC, my lord. Yeah, on the basis of AC's order, respondent number 3 special Tahsildar has reflected this mutation, my lord.
Barkodri, the impugned orders passed by second respondent and confirmed by first respondent deputy commissioner, thereby mutating name of private respondent number 4 to the entire extent of A Karab land.
Not the entire extent, my lord. They say the A Karab has been converted and now my A Karab has been left to B Karab. That I don't know how. They didn't speak anything about that. They only say the A Karab has been converted to cultivated and they have the share for 4 acres as per the compromise decree.
Indirectly, they have allotted to.
Yes, my lord. Indirectly, they have allotted.
Thereby allotting entire A Karab land, thereby mutating fourth respondent's name to the entire A Karab land. Prima facie contrary is found to be contrary to the terms of settlement. Settlement recorded in OS number
479 of 2014, my lord. Old number is 285 of 2012. It is in Magdi, my lord.
479 of 2014 bracket ಅಲ್ಲಿ old number 285 of 2012. On examining the compromise decree passed in the above said suit, they extends the mutation now effected by second respondent assistant commissioner. Clearly contravenes the compromise decree and therefore matter requires consideration. For the reasons stated supra, the impugned orders are stayed until further orders. Issue emergent notice to R4. Learned AG is directed to accept notice to respondents 1 to 3.
Oblige.
Lords, I appear for the petitioner in this matter, my lords.
Yes, sir.
My lords purchased the land under Annexure A, page 8, my lords, on 27/2/2009.
Yes.
There is a mandate on the sub-registrar to send the entries under Form J to the Tahsildar to effect revenue entries, but unfortunately it is not done for a long time. I approached them last year, my lords. They said you submit a representation. I have given it at Annexure C, page 24. Now they are telling because of Bhumi, they will not be able to transfer it, my lords. Technical issues rising.
Yaru, no.
Will consider,
You have to consider.
please.
This is not done. 2009 sealed it.
2009.
For code, caption petition is filed. Learned AG is directed to accept notice to respondents 1 to 3. Caption petition is filed, seeking a mandamus against third respondent Tashildar to consider the representation submitted by petitioner on 12/8/2024, evidence that Annexure C and transfer revenue entries pertaining to petition land bearing survey number 146/8 measuring 1 acre and survey number 147/1 measuring 0.75 acres and survey number 204/1 measuring 0.52 acres. Situated at Negle, Karkali village of Somarpet, Hubli, Swensusan. Next, by the counsel for petitioner and learned AGA. Petitioner is aggrieved by the inaction on the part of third respondent Tashildar in not affecting changes by taking cognizance of registered sale deed obtained by petitioner, which is evidenced at annexure
Yeah, my lord.
A to the
Page
petition.
8.
Section 128 casts a mandatory duty on the revenue authorities to effect changes whenever acquisition of right is reported by a party based on a registered sale deed. The case on hand reflects a very sorry state of affairs. Though petitioner has obtained a sale deed way back in 2009, he is made to run a pillar to post only on the premises that the office of Tashildar has some issue in mutating the names on account of introduction of a new on account of introduction of Bhumi online system. Revenue authorities cannot go on citing lame excuses and postpone the change of kata. More particularly when a citizen seeks change of kata based on a registered sale deed. This is a clear case of laxness on the part of the third respondent Tashildar. The action of third respondent in not acting upon the application submitted by petitioner also indicates that he is guilty of dereliction of duty. Next, at this juncture, learned AGA assures the court, Varila Beda, assures this court that the third respondent Tashildar will take cognizance of registered sale deed and appropriate steps will be taken to effect changes strictly aligning to the conveyance indicated in the registered sale deed, and necessary changes will be reflected in the revenue records pertaining to these petition lands. Recording his assurance, this court passes following order. Repetition is allowed. The third respondent is hereby directed to forthwith effect changes strictly aligning to the conveyance indicated in the registered sale deed dated so and so, evidence at annexure A, and accordingly mutate petitioner's name to the RTCs pertaining to all the petition lands. Next, this exercise shall be accomplished within a period of 6 weeks, in which the matter will be seriously viewed and appropriate action will be initiated against the third respondent Tashildar.
I'm grateful, madam.
Yes.
Application ಕೊಡ್ತಲೇ ಗೊತ್ತಾಗುದಿಲ್ಲ because application ಕೊಟ್ಟು immediately ಮಾಡಿ.
ಅಲ್ಲ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಇಂದ ಬರಲ್ವಾ ಅದೇನೀಗ ಏನದು ಈಗಲೂ ಜೆ ಫಾರ್ಮ್ ಇದೆಯಾ ಅದು ಏನ್ರಿ ಯು ಶುಡ್ ನಾಟ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಇವನ್ an application. What is this? Time and again this court consistently has held that don't wait for an application also. I think something needs to be done. There is no accountability.
ಎಲ್ಲ ಬರುತ್ತೆ ಇವಾಗ 2019 ಈಚೆಗೆ ಫುಲ್ ಎಲ್ಲಾವುದು
ಮತ್ತೆ intimation ಬಂದ್ರೆ ಮಾಡಿ. You tell me why you should engage Arun and shell money from his pocket.
Old lady, 82-year-old lady.
ಎಷ್ಟು
82-year-old lady.
ಮೊದಲೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅರುಣ್.
I'm sorry.
Very sorry. This is not done. All right. Next.
Grateful.
Reserve. 11 reserve. Number 12.
My lord, I request for an adjournment. Senior is not available today, my lord.
You can't say that your senior is not available in a part heard matter.
My lord, there's a family.
And you appear for
exigency.
respondent. You're on the wrong side then.
My lord,
Where's the senior, madam?
He's here only. My friend is here only.
Vijay Kumar sir is.
Huh, ಮತ್ತೆ?
He filed wakalat, NOC wakalat on the earlier meeting.
You assured that you will settle the matter. ಇದೇ matter ಅಲ್ವಾ?
ಹೌದು ಸೇಮ್ ಮ್ಯಾಟ್ರ್.
Yes.
ಎಲ್ಲ ತಾವು ಹಿಯರ್ ಮಾಡ್ಬಿಟ್ಟು ಇದು ಇಷ್ಟಾಗತ್ತೆ ಹೇಳಿ.
ಈಗೇನಾಯ್ತು ನಿಮ್ಗೆ ಕೊಡ್ತಾ ಇಲ್ವಾ ಅವ್ರು NOC?
ಕೊಡ್ತಾ ಇಲ್ಲ, ಫೈಲ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅದರಿಂದ.
They want to engage us, my lord. My lord, I request. an
ಕೃಷ್ಣಮೂರ್ತಿ
adjournment.
ಸರ್ ಆಯ್ತು ಇದು 2005 ಪೆಂಡಿಂಗ್ ಇದೆ ದೇ ಆರ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ಗೆಟಿಂಗ್ ಸ್ಟೇ ಇದೆಯಲ್ಲ ಆಯ್ತು this matter is admitted appeal is admitted what to do 2005 matter
My lord.
ಅಲ್ಲ ಎಲ್ಲ ಆಗಿದೆ.
My senior had a family exigency, my lord. So.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಬೇಕಲ್ಲ.
ಯಾರು who is the senior madam
Kalyan Basuraj sir.
ಅರೆ ಅವರೇ ಅಪಿಯರ್ ಆಗಿದ್ರು ಮುಂಚೆ. he has given no objection. ಇದೆ ಅಂತಿದೆ.
he had given a NOC
But.
ಅವ್ರು appear
the
ಆದ್ರು
client
ನಿಮ್ಮ
wants to
ಹೆಸರು
engage us
ವಿಜಯ್ ಕುಮಾರ್ and you argued already on that
ಮಾಡಿದ್ರಲ್ಲ.
Then.
probably you conveyed to your client and now they don't want to engage your service sorry state
ಇದೆ ಅಂತಿದೆ ಒಳ್ಳೆ not correct. Anyway, I don't want to comment anything.
Just to mention that.
ಅಲ್ಲ at least
taken
I
NOC from me and it has been notified before your lordship.
you filed in wakalat did you file in wakalat
Filed wakalat and they took NOC.
again NOC again they have engaged Kallaina
Same.
all right tomorrow
Please.
tomorrow
Please.
Oblige.
Oblige.
I've heard you
ಅಲ್ಲ ಕರೆಕ್ಟ್ ನಾವು
if they're not interested in settlement we'll pass orders I've heard you who knows
ಕರೆಕ್ಟ್ ಸರಿ ಅಲ್ಲ ಅಂತ.
you may succeed also
ಅಲ್ಲ ಅದು ಬೇರೆ ವಿಷಯ ಅಲ್ಲ ಸರ್ ಸರಿ ಅಲ್ಲ ಅಂತ.
they don't want a settlement we'll record a judgment on merits
ನಾಳೆ ನಾನು ಐ ವಿಲ್ ಫೈಲ್ ಬ್ರೀಫ್
Correct,
ಸಿನಾಪ್ಸಿಸ್ ಆಲ್ಸೋ ಅಂಡ್
yes file a synopsis and we'll decide it
yes please.
Oblige.
tomorrow
Yes sir.
yes next number 13
I'm sorry, I was not here on the last.
yes sir actually
Okay,
sir you
I'm
were not there in the last
I'm sorry, my lord, what is
how
that?
did you miss out you're not aware or there's some inconvenience
I had asked my advocate in record to take time and he was unfortunately ill. I came to know. My lord, I had a talk with Mr. Balkrish Shastri today morning. He had to urgently go to Dharwad. I'm ready in the matter, but the difficulty is this, sir. It has to be fully argued. Though they have filed an application for additional evidence, they have not stepped into the box. Supreme Court clearly said that once you don't, you allege forgery and don't step into the box, you cannot take advantage and you have given up your right to seek expert opinion. My difficulty.
they have examined whom they have examined through GPA
No, they have not examined anybody.
they're not stepped
They
into
did
the
not step into the box. In the earlier suit for possession, they said that evidence will be treated as evidence in this suit. That's why I will argue fully. My difficulty is this, 1 PM, I am going out of the country for 1 week, subject to your lordship's convenience. I am back on 27th.
can't hold this brief either this case either I will decide it or if you're not there then I have to release it next week one day varal and I hear appeals only on Thursdays and Fridays
Allah, 27th early morning, I am back. Your lordship have it on 27th or 30th?
27th.
Subject to your lordship's convenience.
you can take a chance on 27th
27th ಬೆಳಿಗ್ಗೆ ಬರ್ತೇನೆ. I'm ready. Sorry for the inconvenience.
all right
Yes, 27th,
yes
please.
The appellant in the matter.
yes Ajay Kumar
This the Bangalore Development Authority is in appeal in this honorable. The Bangalore Development Authority is in appeal before this honorable court. The suit was filed by, well, it's the,
why the matter was urgent why have urgent
last occasion, Malots, I was not keeping well.
you
I requested Malots to kindly accommodate me for it. Please. The suit is filed, Malots, for possession and for permanent injunction.
permanent injunction
Possession and permanent injunction.
You-
They do
you are
not
the
seek for
defendant?
declaration.
you are the defendant in the suit
Please, I am the second defendant in the suit.
second defendant
Second defendant. What's the crux of the matter is as such, my lords. The social property, my lords, are lands pertaining to survey number 83/1 and 83/4. ಈ ಎರಡು ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಬರುವಂತ ಲ್ಯಾಂಡ್ಸ್
Defend number one.
Defend number 1 is the society. The dispute, in fact, is between the society, Mysore Road Industrial Employees House Building Cooperative Society. Dispute is between the society and the plaintiffs. Illi they are the respondents number 1 to 5 before the honorable court.
Connected matter dispose ಆಗಿದೆ.
Evidence. DW1 evidence.
Not unless there's a connected appeal. There was a connected appeal. That has been disposed of. In fact, so far as the
Paper book.
the paper book was dispensed with. Paper book was dispensed with. My lords, in fact, it's a very short point, my lords.
Show it from.
Along with, I don't have this one. My lords, the entire issue, my lords, arises, I would rather submit, my lords, along with the appeal. The predecessor has produced copy of exhibit P15. If my lords will kindly just refer to that for a moment. Page 49 nalli. Well, so far as the appellant here is concerned, there is only an order of injunction which is passed as against the appellant herein. Possession nam mele illa. In fact, this sketch, my lords, this is produced by us. I mean, originally, this is issued by me, which was produced by the plaintiff. Well, the issue was, there is an encroachment as regards a portion of the property in survey number 83/4 by the first defendant society. Verse 83/1 and 83/4 abutting lands originally were notified by me for the purpose of formation of BTM layout. Madidvi. Subsequently, though possession and all was taken, we have reconveyed the same in favor of the original owner Chinnappa. Though it is not as against the plaintiffs, plaintiff or plaintiff, there is a reference to that effect. Any which ways, I have given up the property. We have not claiming any right as against that property at all. This land, survey number 88/2, E-land alli, we have given a plan sanction to the society. 88/2 particularly, which is one which is abutting the land in 83/4. A sketch nodidre some nimsha, just otherly there is a marked agide.
Yes,
There's a small portion of the land, my lords, which was encroached. In fact, the schedule also as regards encroachment is 364 feet by 20 feet.
Why, how are you aggrieved?
Let's not agree, my lords. Why am I being made a party here and is what the concern is? I had not involved. I have not done anything. For what reason is that I am being made a party?
Any challenge? Why you're taxing BDA for no reason? You have raised litigation expenses, huh?
We don't get our fee.
Why you file this appeal?
Appeal was filed, my lords. Have now NOC there. Anyways, what I could see, my lords, what I could only see, I see what my lords are saying. As against the property against which I have already reconveyed.
The decree is against defendant number 1.
Defendant one only, but only injunction order is operating against me.
Correct.
That's all. There's nothing else. All what I could see, my lords, from this one is, there was no occasion to file a suit against me at all, my lords. I have done absolutely nothing. I have, in fact, the document which has supported the plaintiff.
We'll record your statement. We
Please.
say that BDA has never questioned
BDA has not.
plaintiff's possession.
BDA has not interfered also, my
Okay,
lords.
we'll record it and we'll dismiss it.
Please, means. So short point ittu. Adukoskara last occasion when we were trying to this one, my lords. My lords took it up for further hearing for this reason. In fact, my lords, connected appeal is filed by the purchaser of that other site by the this one was R3 illi. Yeah, sorry, R5 idare.
And you see, defendant number 4 has not challenged this appeal.
Defendant number 4 is not even contesting.
No, but at
Trial court only though they filed written statement, they don't even contest.
At his instance, it was remanded by this court.
Originally.
It was by defendant number 4.
No, my lords. Defendant number 4, please. Defendant number 4, my lords, he filed another an appeal.
Another appeal.
725 of 2013. That was settled. Very recently, it got settled. That's the reason, my lords, no respondent is willing to participate in this matter.
I'll only record a statement.
Please.
That the BDA has never interfered with plaintiff's possession.
Please.
Decree for possession is against defendant number 1.
Please.
Second defendant acknowledges that plaintiff is entitled to seek possession of the property is covered under the decree.
We have already reconveyed.
You have reconveyed.
We have already reconveyed. It's part of my written statement.
We'll say that this decree for injunction is hurting you.
Please, that's all. Because ಅಲ್ಲ reconvey ಮಾಡಿದ ಎಲ್ಲ ಲ್ಯಾಂಡ್ಸ್ ನವರು ಬಂದ ಅಂದ್ಮೇಲೆ ಸೂಟ್ ಆಫ್ ಇಂಜಂಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಅಂತ ಆಗ್ಬಿಟ್ರೆ very limited, nothing further than this.
All right. Good.
Please, great.
Caption first appeal is filed by BDS, second defendant, asserting the judgment and decree rendered in OS 7385 of 1995, which was one for possession and for perpetual injunctions against the defendants. The said suit is decreed. And defendant number 1 is directed to hand over the encroached portion. Next. The defendant number 1 society which has suffered an order, which has suffered a decree for possession, has not assailed the judgment and decree rendered in OS 7385 of 1995. Next paragraph. The second defendant slash BDA has questioned the judgment and decree on the ground that BDA, having reconveyed the suit property and having acknowledged plaintiff's right over the suit properties, erred in granting perpetual injunction against BDA. Counsel would further point out that the plaintiff had no cause of action to array second defendant. And since there is no assertion by second defendant over the suit properties, the learned judge erred in granting perpetual injunction even against BDA. The said portion of the order in this challenge. I've heard the learned counsel appearing for appellant. Perused the pleadings, overland documentary evidence, and the judgment rendered by the trial court. Records reveal following point would arise: whether the judgment and decree rendered by the trial court warrants interference at the hands of this court. Whether the judgment, whether the decree for possession granted by the trial court directing defendant number 1 society to hand over the social properties and consequential perpetual injunction, thereby restraining defendants 1, 2, and 4 from interfering with plaintiff's peaceful possession over the social property. Is erroneous and warrants interference at the hands of this court. Next. On meticulous examination of records, this court has noticed that the social properties were proposed to be acquired by BDA for the purpose of forming a layout, housing society, na?
BTM stage, BTM layout. For BTM layout.
For the purpose of forming housing sites for BTM employees.
BTM layouts. It is BTM layout.
BTM layout.
BTM layout.
For the purpose of laying a BTM layout. Plaintiff has filed the present suit, feeling aggrieved by the high-handedness of defendant number 1 society. Plaintiff is aggrieved by the alleged encroachment made by defendant number 1 while laying a layout pursuant to acquisition of lands by BDA and allotment of bulk allotment made by BDA.
Sorry, 83/4 we had acquired, but we reconveyed in favor of the predecessor of plaintiff. 88/2 we have nothing to do with the land. We have only granted them a sanction plan. That's all. That is the reason how I got involved into this.
Badri Nagaraj. Accused pursuant to grant made by the competent authority. Second defendant has approved the layout.
Please.
In survey number
88/2.
88/2, which was granted to defendant number 1 society.
Please, they have not made any about they have not mentioned anything.
The defendant number 1 society, however, while forming a layout, has virtually encroached over plaintiff's property, bearing survey number 83/1 and 83/4. The official examined on behalf of second defendant authority has admitted in unequivocal terms that lands bearing survey number 83/1 and 83/4 are reconveyed to the plaintiff by the authority. This clinching evidence in the form of oral evidence by the official of authority clearly gives an indication that second defendant acknowledges the plaintiff's title over crucial properties bearing survey number 83/1 and 83/4. Next, the second defendant's grievance before this court is that that though BDA has acknowledged plaintiff's right and possession, the learned judge has granted consequential relief injunction. Counsel has vehemently argued to contend that that learned judge could not have granted perpetual injunction, thereby restraining BDA from interfering with plaintiff's peaceful possession when there is no interference by second defendant authority. Next, though it is a trite law that that court can grant injunction, perpetual injunction, only when plaintiff is able to substantiate interference by the defendants. The fact that second defendant has not set up any rival claim over the social properties, and on the contrary has acknowledged that plaintiff acknowledged that the suit lands were in fact reconveyed by BDA in favor of plaintiff. The perpetual injunction granted by the learned judge restraining defendant number 1, 2, and 4 is of no consequence if a BDA authority is not asserting any right. The consequence, the operative portion of the decree indicating that injunction is operating even against BDA authority will not seriously prejudice the second defendant's rights. If second defendant acknowledge plaintiff's right to secure possession, this court is of the view that that there was no cause of action subsisting to prefer an appeal before this court. Next paragraph. Defendant number 1, who is now under the decree called upon to hand over vacant possession of encroached portion, has not challenged the judgment rendered in OS 7385 of 1995. The judgment and decree rendered by the trial court is based on evidence let in by plaintiff, more particularly Exhibit P15, coupled with the evidence of DW1 examined on behalf of BDA, second defendant BDA. Therefore, this court is of the view that there is no error committed by the learned judge while decreeing the suit. If second defendant is not asserting any right and title, no indulgence can be granted by this court. Accordingly, point formulated by this court is answered in the negative. After the debate of merits, upon instant.
Great.
Number 15. Yes, Srinivas.
I appear for the appellant in RFA 1975 of 21, Your Honor.
My lord, in my cross objection, I filed a LR application, my lord, to bring the LRs of respond number 33 and 35 and 36.
What is the crop by plaintiff?
Yes, ma'am. I am the defendant, LRs of defendant.
ಅದರಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಗಬೇಕಾ ಸರ್ವಿಸು?
ಸರ್ವಿಸ್ ಆಗಿದೆ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿದ್ವಿ.
ಸರ್ವ್ ಆಗಿದೆಯಾ? You should be only permitted to bring them on record.
Yes, ma'am. I used to be allowed.
Crop ದಲ್ಲಿ ಬರ್ಕೊಡ್ರಿ. ಯಾರು? Who has died?
My lord. Respond
33, 34.
33, Kempaya.
56, 53, 55, 30. Yaru, who has died?
My lord, Kempaya, respond number 33. 35 Srinivas and 36 Jai Krishna. In my
Respond
cross
number
objection.
33.
Yes, madam.
And all the LRs are served through hand summons, huh?
Yes, madam.
And an affidavit is filed.
Yes, my lord. Affidavit is filed in respect of respond number 33B, D and F, my lord. They refuse to receive the hand summons.
So you have filed an affidavit to
We
that.
have filed a affidavit.
And what about others?
Others, they have received it and memo has been filed along with the acknowledgement. Alla, ಇದು
Crop ಅಲ್ಲಿ,
Crop
first
ಅಲ್ಲಿ,
matter
crop
ಇನ್ನ serve ಆಗಿದೆ. 1975 ಅಲ್ಲಿ ಇನ್ನ serve.
They are not brought as parties.
ಸ್ವಾಮಿ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 1975 of 21 ಅಲ್ಲಿ ಅವೇಟ್ ಸರ್ವಿಸ್ ಅಂತ ಇದೆ. ನಾನು 23 ಮತ್ತೆ 24 ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್. ಅವರೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತರಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ, ಅದ್ರ ಮೇಲೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಿತ್ತು. ಸೊ ಅದು ಇನ್ನ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, ಅವೇಟ್ ಅಂತಿದೆ. ಮತ್ತೆ R14 ಮತ್ತೆ 15 ಕೂಡ ಅವೇಟ್ ಅಂತ ಇದೆ ಅಂದ್ರಲ್ಲಿ. ಮತ್ತೆ ಇಲ್ಲಿ 21 ಅಲ್ಲಿ ಏನಾಯ್ತು, ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಒನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ R21. ಅದ್ರಲ್ಲಿ ಡಾಟರ್ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ ಬೈ ಮಿಸ್ಟೇಕ್, ಅದು ವೈಫ್ ಆಫ್ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಎಲ್ಲ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ we can allow all those applications.
ಹೌದು ಸ್ವಾಮಿ, ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್.
ಈಗ ನಿಮ್ ಮೇನ್ ಅಪೀಲ್ ಅಲ್ಲೂ ಸರ್ವಿಸ್ ಇನ್ನೂ ಅಬೇಟ್ ಇದೆಯಾ?
ಮೇನ್ ಅಪೀಲ್ ಬೇರೆದು.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
ಮೇನ್ ಅಪೀಲ್ ಬೇರೆದು ಸ್ವಾಮಿ. ಅದು
ನನಗೆ ಇವರು ಏನ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ, ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. ಕಾಪಿ ಕೊಟ್ರೆ ನಾನು
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಮ್ದು.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಕೊಟ್ರೆ ನೋಡ್ಬಿಟ್ಟು ನಾನು ಹೇಳ್ತೀನಿ.
ಸ್ವಾಮಿ 492 of 2003 is the main matter, my lord.
ಅದ್ರಲ್ಲಿ ಎಲ್ರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆ. ಅದ್ರಲ್ಲಿ ಏನಾಗೋಯ್ತು, ಅವ್ರು ನನ್ನನ್ನ ಪಾರ್ಟಿನೇ ಮಾಡಿರ್ಲಿಲ್ಲ. ಯಾಕಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೆಣ್ಮಕ್ಳಿಗೆ ಏನು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. ಸೊ ಹಂಗಾಗಿ ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ. ಹಂಗಾಗಿ ಅವ್ರು ಲೀಗಲ್ ಏರ್ಸ್ ನ ಕೂಡ ತರ್ಲಿಲ್ಲ. ಕ್ರಾಬ್ ಅಲ್ಲಿ ಏನಾಯ್ತು, ಕ್ರಾಬ್ ಹಾಕೋಷ್ಟೊತ್ತಿಗೆ ದೇ ಹ್ಯಾವ್ ಬ್ರಾಟ್ ಆಲ್ ದ ಲೀಗಲ್ ಏರ್ಸ್ ಆಫ್ ದ ಡಾಟರ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್.
ಈಗ ಕ್ರಾಬ್ ಅಲ್ಲಿ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿಬಿಟ್ಟಿದ್ಯಾ?
ಕ್ರಾಬ್ ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
Why you have filed 2 appeals, madam?
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ನಾನು ಕ್ರಾಬ್ ಹಾಕಕ್ ಹೋಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ನನಗೆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆದ್ಮೇಲೆನೆ ನನಗೆ ವಿಷಯ ಗೊತ್ತಾಗಿದ್ದು. ಐ ಆಮ್ ದ ಚಿಲ್ಡ್ರನ್ ಆಫ್ ಡಾಟರ್ಸ್. ಇಲ್ಲಿ ಮೇನ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನನ್ನ
Where is the family tree?
Family
ಕ್ರಾಸ್
tree.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ
Ah,
RFA ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ
ah.
they have prayed for dismissal of the suit. Prayed for dismissal of suit. Therefore, that would be more relevant to be heard first. If suit is dismissed, these both this appeal will not arrive.
ನೋಡೋಣ, ಒಂದ್ ನಿಮಿಷ ನೋಡೋಣ ಇರಿ.
ನನಗೊಂದು ಕಾಪಿ ಕೊಟ್ರೆ I will make my submission.
ಕೊಡೋಣ ಬಟ್ ಸ್ವಲ್ಪ ಹೇರ್ ಮಾಡಿ ಕಾಪಿ. Why you not served a copy on?
ಅಲ್ಲ, we have served it, but I don't know.
You all are selling together, Who is the plaintiff here? Who is the plaintiff?
ಪ್ಲೇಂಟಿಫ್ ಇಲ್ಲ, ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನ್ ಪ್ಲೇಂಟಿಫ್ ಇಲ್ಲ, ನಾನು ಡಿಫೆಂಡೆಂಟ್ ಗೆ.
492 appellant is the plaintiff. 492 ನಲ್ಲಿ appellant ಇದಾರೆ
ಅವ್ರು ಪ್ಲೇಂಟಿಫ್ ಗೆ, ಅವ್ರು ಬಂದಿಲ್ಲ.
ಯಾರು? ಜಯಶ್ರೀ ಶ್ರೀನಿವಾಸ.
ಹೌದು,
ಜಯಶ್ರೀ ಮೇಡಮ್
ಅವ್ರು ಯಾವಾಗ್ಲೂ ಇರ್ತಾರೆ, ಇವತ್ತಿಲ್ಲ. ಇಲ್ಲ ಬರ್ತಾರೆ.
Regularly absent ಅವರು.
ಇಲ್ಲ ಇಲ್ಲ,
ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರೇ ಡೇಟ್.
ಇಲ್ಲ ಬರ್ತಾರೆ. ಐ ಶುಡ್ ನಾಟ್.
ಕೊಡ್ರಿ, ಫೈಲ್ ಕೊಡಿ. ಫ್ಯಾಮಿಲಿ ಟ್ರೀ
Partly decreed, my lord. Suit is partly decreed, wording that some of the self-acquired properties and some are the joint family properties. In the main suit, the sisters also parties, but in para number 12, it was held that the time,
ಅದೊಂದು
as per the
ನನಗೊಂದು ಕಾಪಿ ಕೊಡಪ್ಪ ಇದು. ಫೋನ್ ನಂಬರ್ ಕೊಡ್ತೇನೆ. ಕಾಪಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. I want to also talk with you.
So in our family,
ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ. suit is dismissed.
ಸೆಲೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಹೌದಾ, ಅದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಣ ಅಂತ ಆಮೇಲೆ
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀವಿ ನಾವು. 15 along with filing person.
ನೀವೇನು ಒಂದು ನಿಮಿಷ ನಮ್ಮ ಪಾರ್ಟಿ ಬರ್ತಾರೆ. ರಿಸೀವರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಪಾಯಿಂಟ್ ರಿಸೀವರ್ ಕಲೆಕ್ಟ್ ಇದೆ.
ಸುಮಾರು
ಹೌದು, ಪಾಯಿಂಟ್ ರಿಸೀವರ್ ಕಲೆಕ್ಟ್ ಇದೆ. Direct into deposit, rent into. Direct into deposit, rent into direct period. ಎರಡು application ಮಾಡ್ತಾರೆ. ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, it is a problem. ಒಂದು ಕರೆಸಿ ನಾನು ready ಮಾಡ್ಕೊಡ್ತೀನಿ. ಇವರೇ ನೀವು 13 ಕರೆಸಿ ನಾನು ready ಮಾಡ್ಕೊಡ್ತೀನಿ. ನಮ್ಮವನು ಬರ್ತಾ ಇಲ್ಲ, ಅವನೇನೋ ಕಾಯಿಲೆ ಬಿದ್ದುಬಿಟ್ಟು ಇನ್ನೊಬ್ಬ ಬರ್ತಾ ಇದ್ದ ಏನೊಂದು ಕೆಲಸ ಮಾಡ ಹೇಳ್ತೀನಿ, ನಾನು ಮಾಡ್ಕೊಡ್ತೀನಿ. ನಮ್ಮನು ಬರ್ತಾ ಇಲ್ಲ, ಅವನು ಕಾಯಿಲೆ ಬಿದ್ದುಬಿಟ್ಟವನೆ. ಆಮೇಲೆ ಇನ್ನೊಬ್ಬ ಇದ್ದ ಬ್ಯಾಂಕ್ನವನು, ದಿ ಪರ್ಚೇಸರ್ ಆಫ್ 84 and 85, ಅವನಿಗೆ ಬ್ರೈನ್ ಎಫೆಕ್ಟ್ ಆಗ್ಬಿಟ್ಟು ದಟ್ ಈಸ್ ಐ ಆಮ್ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ಡ್, ನೋಬಡಿ ಇಸ್ ಕಮಿಂಗ್.
Where's the family tree, madam?
Yes, my lord, I have produced the family tree along with.
Produced?
ಮಾಡಿ.
It's a fresh family tree.
ಹೌದು ಹೌದು, RFA ದಲ್ಲಿ 1975 ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ ನೋಡಿ family tree? Why plaintiff has filed appeal?
ಸ್ವಾಮಿ ಅಲ್ಲಿ ಏನಾಯ್ತು, ಹೆಣ್ಮಕ್ಳಿಗೆ ಮಕ್ಕಳಿಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Para number 12 of the judgment.
Subsequent to the para number 12 of the judgment may be looked into.
Para 12.
ಹೌದು.
Who are the plaintiffs? The plaintiffs are, madam.
Plaintiff ಬಂದಿಲ್ಲ.
Plaintiff
Plaintiff is not before this court, Your Honor.
Plaintiff appellant.
Appellant is not before this court. I appear for my appeal is
No, no,
defendant appeal.
You brought to my notice that there is an appeal by plaintiffs also.
Yes, yes.
That is the main appeal, madam.
Main appeal.
ಈ ಫ್ಯಾಮಿಲಿ ಟ್ರೀದಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ಸ್ ಯಾರು ಅಂತ ಕೇಳ್ತಾರೆ.
ಹಂಗ, ಹಾ, ಓಕೆ.
ನೀವು ಬರ್ದೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಸ್ವಾಮಿ ದೊಡ್ಡ ಪೂಜಪ್ಪ.
ದೊಡ್ಡ ಪೂಜಪ್ಪ.
ಅವರ ಮಕ್ಕಳು ರವೀಂದ್ರ.
Oh, they are the plaintiffs.
ಅವ್ರ plaintiffs.
They are the plaintiffs.
ಹೌದು. ನಾನ್ ಬಂದು ದೊಡ್ಡ ಪೂಜಮ್ಮ ಇದಾರಲ್ಲ ಸ್ವಾಮಿ, ಅವರ ಮಕ್ಕಳಿಗೆ ನಾನು.
Correct. And they were ಯಾರ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಅವರು?
ಇವ್ರು ಬಂದ್ 7th ಡಿಫೆಂಡೆಂಟ್. ಅವ್ರು
7th ಡಿಪೆಂಡೆಂಟ್.
ಅವರು ಪ್ಲೇಂಟಿಫ್ OS ಹಾಕೋತಾರಲ್ಲ, ಅದ್ರಲ್ಲಿ ನಾನ್ 7th ಡಿಫೆಂಡೆಂಟ್ ಆಗಿ ಇದ್ದೀನಿ.
What's your name? 7th defendant name?
ಸಿದ್ದಪ್ಪ, ಚಿಕ್ಕಣ್ಣ, ರಾಮಕ್ಕ.
ಅವರೆಲ್ಲ D7, D8.
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
You tell me, D72?
D72, I'll just.
Chicken also died. Chicken was arraigned as?
LRs of D7.
Chickana is arraigned as 7B.
Chicken was arraigned as?
7B. OS judgment ತಾವ್ ನೋಡಿದ್ರೆ 7B.
7B.
ಸಿದ್ದಪ್ಪ is 7A.
7B. ಸಿದ್ದಪ್ಪ is 7A.
ಹೌದು. ರಾಮಕ್ಕ is 7G.
7G.
G.
Correct.
ಸಾಕಮ್ಮ is 7I.
7I. ಕೆಂಪಯ್ಯ?
ಕೆಂಪಯ್ಯ is 7C. ಶ್ರೀನಿವಾಸ್ ಇಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಶ್ರೀನಿವಾಸ್ ಇಲ್ಲ.
ಇವರೆಲ್ಲ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ಲ.
ಮುನಿಯಮ್ಮ 7J. ಜಯಕೃಷ್ಣ is 7F.
7F. ಶ್ರೀನಿವಾಸ್ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲಿ ಅದೇ ಅವರು ಮಾಡಿಲ್ಲ.
All right. Now, Dodda Pujapa's branch have filed this suit. And who is contesting defendant?
Contesting defendant is the
First defendant.
first defendant.
ಯಾರು? ಯಾವ ಬ್ರಾಂಚ್ ಅದು? ಡಿಫೆಂಡ್ ನಂಬರ್ 1.
ಅವರು
H Pujappa.
H Pujappa.
ಚಿಕ್ಕ ಪೂಜೆ.
He says all these properties, suit is dismissed over.
Defend number one na. ಎಲ್ಲಿದ್ದಾರೆ ಫ್ಯಾಮಿಲಿ ಟ್ರೀದಲ್ಲಿ H Pujappa ಎಲ್ಲಿದ್ದಾರೆ?
Family tree ದಲ್ಲಿ serial number 2.
ಚಿಕ್ಕ ಪೂಜಪ್ಪ.
Correct.
One is Dodda Pujappa is the plaintiff. Chikka Pujappa is the first defendant.
ಅಲ್ಲಿ ಬರಿಬೇಕಾದ್ರೆ H Pujappa ಅಂತ ಯಾಕೆ ಬರೆದ್ರು ಮತ್ತೆ? ತಂದೆ ಹೆಸರು ಅದು ಇನಿಷಿಯಲ್.
Uchappa is the
ಪ್ರಪೋಸಿಟರ್.
propositor.
He died during the pendency of the suit, madam.
ಅಲ್ಲ ಇದು
Chikka Pujappa was alive when this partition.
Yes, my lord. During pendency of.
All right, D1, he is D1. They are all LRs of D1. ಇವರೆಲ್ಲ.
Please.
What was the defense of first, defense number one ಯಾರು appear ಆಗೋದು?
I appear LRs of first defendant, madam.
You appear for LRs.
Having the single LR,
ಒನ್ ಆಫ್ ದ LR.
one of the LR.
All right, your contention is that these properties are self-acquired.
Self-acquired property.
I appear for 1B. 1C, Manjunath.
1C Manjunath. ನೀವು ಅವರು ಎಲ್ಲ ಒಂದೇ. All right. Who appears for Nagappa?
Nagappa, I have prefer only one branch of that
ನೀವು ಯಾರಿಗೆ appear?
2A died, my lord. I appear for the LRs of 2A. Defendant number 2A, LRs.
H ನಾಗಪ್ಪ ತೀರೋಗಿದ್ದಾರೆ.
ಆ ಬ್ರಾಂಚ್.
ಆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ
ನೀವು ಆ ಬ್ರಾಂಚ್. You are supporting plaintiff or supporting defendant number one? Whether you filed written statement.
Plaintiff, you are supporting plaintiffs.
ಈಗ ಅವ್ರೇನ್
ನಿಂಗಮ್ಮ ಅಂತ ಒಬ್ರು ಹೆಣ್ಮಗಳು ಅಲ್ವಾ?
ಹೌದು, ಅವ್ರಿಗೆ ಯಾರು ಇಲ್ಲ.
ಯಾರು appear ಆಗಿಲ್ಲ.
7 are the female heirs.
All right, 4 sons and 1 daughter.
Please. 4 sons ಅಲ್ಲ.
3 sons.
3 sons.
ಎಲ್ಲಿ?
Pujappa,
ದೊಡ್ಡ
H
ಪೂಜಪ್ಪ,
Pujappa,
ಚಿಕ್ಕ ಪೂಜಪ್ಪ, ನಾಗಪ್ಪ.
3 sons and 2 daughters.
Yes, ma'am.
Nagappa are the sons and Ningamma and
All right, then we have
Pujamma.
to only examine finding on self-acquired.
ಅಷ್ಟೇ.
Issue number.
ಹೌದು. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 12 ತಾವ್ ತಗೊಂಡ್ರೆ.
Huh?
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 12, my lord.
12.
ಹಾ. 12 of the judgment.
Huh?
Regard to 4 property, if it is held to be self-acquired, all appeals will go.
All appeals will go.
ಅಲ್ಲ ಹೋಗೋದಿಲ್ಲ ನಂದು. ನನ್ಗೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಹೆಣ್ಮಕ್ಳು ಇರೋದ್ರಿಂದ ಐ ಆಮ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಎ ಪಾರ್ಟಿಷನ್.
ಅಲ್ಲ ಹಾಗೆ ಹೇಳೋದು. They are held to be self-acquired.
Held to be.
Self-acquired property.
Tax granted property, they will get it.
Yes.
Get it.
Otherwise, the Pujappa children will get everything.
Correct.
ಇಲ್ಲಿ 12 ಅಲ್ಲಿ ಸ್ವಾಮಿ.
And you set up self-acquisition in respect of all the properties or only few properties?
ಇಲ್ಲೇನಾಗುತ್ತೆ ಸ್ವಾಮಿ, ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿರೋದು ಶೆಡ್ಯೂಲ್ 1, 2, 10, 11 and 15 ಅದರ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅಂತ ಕೊಡ್ತಾರೆ. Remaining.
Not leave any property. Pujappa did not leave any property.
He had no properties.
He had no property. In fact, he was in debts. The property acquired by him was sold in the court action.
All right, we'll examine how it is discussed by the trial court.
What they say is, plaintiff says that he was contributing all his salary to the hands of the first defendant, and first defendant purchased the property from that amount.
ಎಲ್ಲಿದೆ? Para 12 ಎಲ್ಲಿದೆ?
Para 12 ಅಲ್ಲಿ the plaintiff has claimed decree.
Wait, ಎಲ್ಲಿ page number?
Page number 52.
Such plea was not advanced to the plaintiff.
Plaintiff ಅಲ್ಲಿ ಇರಲಿಲ್ಲ.
Plaintiff advance plea ಇಲ್ಲ.
Like
ಎಲ್ಲಿ ಯಾವ page ಅಲ್ಲಿ madam?
page number 52 money.
Judgment.
Internal page.
Judgment, internal page.
Internal page. Type.
Internal page 52. Paragraph number 12, issue 5. Plaintiff has claimed, my lord, decree of for 1/3 share in all the suit properties and for possession of his 1/3 share.
No, I think not issue number.
Issue number 5.
ಇಲ್ಲ ಅದಲ್ಲ.
Judgment, page number 52, my lord.
Issue framed on 22/6/1995. Issue number 3.
Issue 3 ಆದ್ಮೇಲೆ issue 5, my lord.
Issue 5 ಅಲ್ಲ madam.
Issue 5 ಬಂದ್ಬಿಡಿ.
Issue number 3 ಮೇಲೆ finding.
3 ನಲ್ಲಿ
framed on 22/6/1995.
Issue number 3 and 4, 27 ಬರುತ್ತೆ ಸ್ವಾಮಿ ಅದು page number.
Framed on.
ಅದಾದ್ಮೇಲೆ 52, my lord.
Yes. Yes, share is only granted in 1, 2, 10, 11 and 15.
Yes, yes.
The one which were reconveyed by Mallaya, Mallaya.
Clearly because the statement is there. And Malaya and Malaya's
Maternal uncle. He was a maternal uncle.
uncle. It does not mean that the property remained as a joint family property because consequently it is paid to Malaya. I'll argue it on another day.
Madi, Nale ತಗೊಳ್ತೀನಿ. See, this maybe, I think first defendant is able to demonstrate that this, as of now, I read the only judgment. Item 3 to 9 and 12 to 14 appears to be self-accord property. But the quantification is wrong.
Both the brothers were purchasing the property individually on their own. Even plaintiff has been purchasing property from time to time.
Time to time.
The links are there. He did not include any of the properties.
ಆಯ್ತು ಹುಚ್ಚಪ್ಪನ್ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ?
Death of Huchappa, see, what they say is that I was paying the entire salary to the Pujappa. That is the first evidence. Because he was the Karta.
Correct.
But no proof is there.
No pleadings, no pleadings.
Therefore, the absence of any contribution to be shown, the purchases made by this Malaya, from Malaya, Pujappa.
Yes.
Or the statement before the claim made before the Invalid Act. Would not come in the way of saying that the property remained out of that.
Now why defendant number 7 ಈ ದೊಡ್ಡ ಪೂಜಾಮನ್ ಮಕ್ಕಳು ನೀವೇನು ಇದು ಈ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಬೇಕಂತನಾ?
ಇಲ್ಲ, ನನಗೇನು ಅಂದ್ರೆ ಐ ಆಮ್ ಆಲ್ಸೋ ಎಂಟೈಟಲ್ ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್, ಐ ಆಮ್ ಆಲ್ಸೋ ಎಂಟೈಟಲ್.
No share is granted to you.
ಇಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ.
Will, in the event, if the court were to hold that, the judgment of the tribunal is correct. In that event, all of them will get the share, if nobody can object for it.
Correct.
Nobody can object for it.
Only in item number 1, 2, 10, 11 and 15.
Yes. In the event it is held that it is not joint family property, then only this Pujappa sons, they have to divide the property.
Correct.
ಹೇಗಾಗುತ್ತೆ?
Therefore,
ಅದು ಹೇಗಾಗುತ್ತೆ?
Allah, if I confirm, even if I confirm the judgment of the trial court, only we have to modify the shares
Shares ಅಷ್ಟೇ.
in only four items.
Nobody can object for that because not only that, the remaining properties which are remained, the subsequent properties of Pujappa, the daughters have also made the other suit order. Some order can be made in the suit order.
ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ?
ನಾನು appeal ಆಗಿಲ್ಲ.
Where is the matter?
My sister has filed the appeal.
Correct.
I can only make my submission and order for 41 rule 33.
Correct.
In view of the cross appeal filed by my sister.
Although there is no evidence, suit is rightly dismissed insofar as how many items?
3, 9, 12 and
3 to 9, 12 to 14.
3 to 9.
Holding to be your self-accord property. We'll examine.
My difficulty in not winning in, I am comparing for 1B. He has fallen sick. From last 10 years, he has paralysis.
Aidbadri, you just justify this judgment insofar as dismissal is concerned. They are held to be a self-accord property. No, if we confirm that, you should be happy.
No. So far as other properties are concerned, there are also self-accord properties.
ಇಲ್ಲ, ಅದು ರೀಕನ್ವೆನ್ಸ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಬರೀ 100 ರೂಪಾಯಿ ಕಟ್ಟಿದೀರಾ, 3 ಎಕರೆ ಜಮೀನು ಮಾರ್ತಾರೆ.
I will explain to that.
And there is no appeal by you. So you can't.
But cross appeal is there.
I filed a cross appeal.
You have filed.
My friend.
Then you can argue.
Cross appeal is there.
Then you can argue.
He is none other than my
Brother.
sisters. Therefore, I will make the submission.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ, ಇದು ಯಾವಾಗ ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿದ್ದೆ ಯಾವಾಗ ನೀವು?
It is in the year 2019.
In trial court also no summons was done.
ಡಿಲೇ ಕಂಡೋನ್ ಆಗಿದೆಯಾ? ಯಾವಾಗ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದೀರಿ?
ಇನ್ನ ಇಲ್ಲ ಸರ್.
ಇನ್ನ ಇಲ್ಲ ಸರ್.
ಜಸ್ಟ್ ಫೈಲ್ಡ್, ದಟ್ಸ್ ಆಲ್. ಸರ್ವಿಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇದೆ.
The delay condemnation game ಬರೋದು
ಅಲ್ಲ, ಈಗ
ಅವ್ರು ಹೇಳಿದ್ರ ನಿಮಗೆ ಅಡ್ವೈಸ್ ಮಾಡಿದ್ರ ಹಾಕ್ರಿ ಅಂತ? ಅಡ್ವೈಸ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, ಈಗ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ, 3 ಜನ ಗಂಡ್ಮಕ್ಳು ಶೇರ್ ಮಾಡ್ಕೊಳಕ್ ರೆಡಿ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೆಣ್ಮಕ್ಳನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಹೀಗ್ ಮಾಡಕ್ಕೆ
ನಿಂಗಮ್ಮ ಜೆಲ್ಲಸ್?
ಅವ್ರು ಯಾರು ಇಲ್ಲ ಸರ್.
No Ellas.
No.
Already then 4 shares.
ಅಷ್ಟೇ.
1/4
share. Please. If the judgment is confirmed, 1/4 share.
Alright, as of now, I think 1/4 share in item number 1, 2, 10, 11 and 15.
Yes, my lord.
Please.
Subject to your argument. Part heard.
One only, they described 4 properties. A, B, C ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರು.
Already come with a list.
Yes.
Which way the adjacent properties, when they were sold, to whom they were sold, and what are the properties they are purchased by you. You were also employed, you were employed Allah.
Defendant number one was employed.
You were Chikku Pujappa.
Ah,
You was employed.
he wasn't. Any short accommodation, my lord. Anyway, your honor has read the
My
papers.
lord, on my LR application may be allowed.
Next Thursday though,
Yes, my lord.
partner and no adjournment.
Please.
LR
ಇದ್ರಲ್ಲಿ ಏನಾಗಬೇಕು?
LR application may be allowed.
ಅವ್ರಿಗೆ ಯಾರ ಪೇರ್ ಆಗ್ಬೇಕು? ಯಾರು ಅವ್ರು ಎಲ್ಲರೂ?
Respond number 33 ಗೆ
33,
already the madam.
Madam can take notice.
I can take notice, madam.
Except respond number 33, ಯಾರು ಮೇಡಮ್?
ಹೀಗೆ ಬಿಟ್ಟು.
ಅಲ್ಲಿ ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ ಈಗ ನೋಟಿಸ್
ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. IS may be allowed.
Condemnation delay is concerned, the division method of Honorable Court has took the lenient view. That Padmavati's case, 20,
ಆಯ್ತು ನೋಡನ್ರಿ.
All the IS may be considered along with the mean.
To uphold the judgment, preliminary decree granted by the court below, we can dismiss even on the ground of delay also. What is the delay? How much is the delay?
ಆರು
ಆಯ್ತು
ವರ್ಷ.
ಬಿಡಿ. ಮೆರಿಟ್ ಮೇಲೆ ಮಾಡೋಣ. We'll decide it on that.
division method condone the delay.
ಆಯ್ತು ರೀ ಮಾಡೋಣ.
Really south, 4,000 days.
ಮಾಡಿ. Next Thursday, part third. ಇದು ಈಗಲೇ ಅಲೋ ಮಾಡ್ಬೇಕಾ?
LR application.
ಯಾವ್ದ್ರಿ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇದೆ?
Respond number 33 ಗೆ 35 ಗೆ
36.2.
Where are those applications, Mr.?
My lord, it is IA number
ಇವರು where are those applications?
IA number 1 of 24, my lord. It is at office note number 5.
One of 24, huh?
Yes, my lord. 1 of 24 to 6 of 24, along with the delay application and abatement application for respond number 33. IA 4 to 20, 4 to 6 is in respect of respond number 35. IA 7 to 9 in respect of respond number 36.
35 to A to C.
Yes.
ಅವ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ, ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿ
Cargo serve ಆಗಿದೆ.
ಬರ್ಕೊಡ್ರಿ. Respond number 33 and respond number 35 are reported to be dead. Applications were filed, notices are served.
33, 35, 36.
Huh?
33, 35, 36.
Respond number 33, 35 and 36 are reported to be dead. Applications are filed in that regard to bring legal heirs of disease respondents. 33, 35 and 36. The legal heirs of disease respondents are served and they have not chosen to contest these applications. This court has already indicated in the cause list that services are served and services held to be sufficient. As there is no contest to these LR applications, applications filed in I number so and to are all allowed. The cross objector is hereby directed to amend the cause title.
Yes.
ನೀವು ಯಾರಿಗೆ ನೋಟಿಸ್ ತಗೋತೀರಾ?
33 A to D. ಮತ್ತೆ F.
So and so accept notice to respondents 33 A to D
And F, my lord.
and F. ಈಗ ಮಾತ್ರ ಇಲ್ಲ.
ಇಲ್ಲ.
All right.
I've filed affidavit, my lord.
ಒಂದ್ ನಿಮಿಷ, registry to show her name. ಈಗ ಅದು affidavit ಒಂದಿದೆ, ಅದನ್ನು ಬರ್ದ್ ಬಿಡ್ರಿ. The cross objector has filed an affidavit on 29/8/2024 indicating
33B, D.
that respondents 33B, D and F ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರೆ,
Notice ಆಗಿದೆ.
ಅವ್ರು accept ಮಾಡಿದ್ದಾರೆ.
Yes.
have refused to accept summons and therefore an affidavit is filed to that effect. Since counsel has already tendered appearance and has given an undertaking that she would file in wakalat to respondents 33B, D and F, the affidavit dated 29/8/2024 does not survive for consideration.
Problem.
Cross objected to amend the cause section.
My lord, in my appeal, my lord.
ನಿಮ್ಮ appeal ಅಲ್ಲಿ ಏನಾಗಿದೆ?
ನನ್ನ appeal ಅಲ್ಲಿ ಸ್ವಾಮಿ await service of emergency notice to R14 and 15 ಅಂತ ಇದೆ.
ಅವ್ರು ಯಾರು R14
ಅವ್ರು ಪರ್ಚೇಸರ್ ಆಗ್ತಾರೆ. ಇವರು ಇದರಲ್ಲಿ ಡಿಲೀಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಮೇನ್ ಅಪೀಲ್ ಅಲ್ಲಿ.
ಅವ್ರ appeal ಡಿಲೀಟ್
ಡಿಲೀಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅದನ್ನ ನಾವು ನೋಡೋಣ ಬಿಡಿ.
ಆಯ್ತು sir.
Or are they pendant right purchaser or they have purchased much prior to filing of the suit?
Prior to.
Huh?
Prior to.
Prior to filing of the suit.
ಆಮೇಲೆ
ಯಾವ್ದದು ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದು?
ಅದು ಐ ವಿಲ್ ಬ್ರಿಂಗ್ ಇಟ್
ನೀವು
ಮತ್ತೆ ಇನ್ನೊಂದೇನು ಅಂತ ಹೇಳಿದ್ರೆ 6/23/24 ತೀರೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಐ ಹ್ಯಾವ್ ಬ್ರಾಟ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್.
whether they are allowed or not.
ಇಟ್ ಇಸ್ ನಾಟ್ ಎಟ್ ಅಲೌಡ್.
ಅವ್ರು ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ?
ಅಲ್ಲ ಅವ್ರಿಲ್ಲ, ಬಟ್ ಅವರು ಕೂಡ ಹಾಕಿದ್ರು 35 ಮತ್ತೆ 36 ಅದು ಅಲೋ ಆಗಿದೆ ಇವಾಗ. ಸೊ ಸೇಮ್ LRs ಐ ಹ್ಯಾವ್ ಬ್ರಾಟ್ ದೆಮ್ ಆನ್ ರೆಕಾರ್ಡ್.
ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ ಅದು ಅಪ್ಲಿಕೇಶನ್? ನಿಮ್ದಿಲ್ಲ ಪುಟ್ಟಪ್ಪ ಆಗಿಲ್ಲ?
ಆಗಿದೆ ಸ್ವಾಮಿ, ಪುಟಪ್ ಆಗಿದೆ.
ವೇರ್ ಇಟ್ ಇಸ್?
ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಪುಟಪ್
ಓ
ಆಗಿದೆ.
ನಿಮ್ದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲ ನಿಮ್ದು?
ನಂದು ಹೌದು 1975.
23A to C ನಾ?
ಹೌದು 23 ಮತ್ತೆ 24.
You take hand summons.
ಅಲ್ಲ, ಸಿನ್ಸ್ ದೇ ಆರ್ ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್, ಕ್ಯಾನ್ ಇಟ್ ಬಿ
You
ಟೇಕನ್?
you take a hand summons.
ಆಯ್ತು sir.
So that will
Aye.
see what can be done on the next date. Will hold the service sufficient.
ಆಯ್ತು
But at least you take a hand summons to them.
ಆಯ್ತು 23 and
Since
24 I
matter
take.
is heard in part, and the respondents, and this court has noticed that respondents 23A to C are served in the connected
ಅಲ್ಲಿ.
cross appeal, alla?
ಹೌದು.
Cross appeal. The appellant in RFA 1975 of 2021 shall serve the copy of appeal memo and applications on the proposed LRs by way of hand summons,
ಆಯ್ತು.
returnable by
24th ಹಾಕೊಂಡು
ಅದೇ
26th ಹಾಕಿದಿರಿ ಸರ್.
26th,
Aye.
returnable by 26th. ಇದೇನು memo reporting death of appellant number 1?
ಒನ್ ಅಪಲೆಂಟ್ ನಂಬರ್ 1 ತೀರೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ, ರಾಜೇಶ್. ಅವ್ರ LRs ಆರ್ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್.
They are already on record.
2 to 5, 2 to 4, 2 to 3 minor. They are already on record.
ನಿಮ್ದು ಡಿಲೇ ಇದೆಯಾ? 6,136.
ಹೌದೌದು. ನನ್ಗೆ ಅವ್ರ
ಮಾಡಿ.
ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ನನಗೆ ಗೊತ್ತಾಗಿದ್ದು, ಅಲ್ಲಿ ತನಕ ಇದೆ.
Will pass orders on the next
ಆಯ್ತು.
date. Next Thursday.
ಮತ್ ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೆ.
ಅದನ್ನ allow ಮಾಡೋಣ. ಅದು ಈಗಲೇ ಮಾಡ್ಬಿಡೋಣ.
ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ಇದು 21 ಮುನಿಯಮ್ಮ
Yes.
ಡಾಟರ್ ಆಫ್ ಲೇಟ್ ಪೂಜಮ್ಮ ಅಂತ ಬರ್ಬೇಕಿತ್ತು, ಅದು ಬೈ ಮಿಸ್ಟೇಕ್ ಸಾಕಮ್ಮ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ. 21.
Where is that application, amendment
I
application?
have filed my lord.
I number?
Is no more. ಯಾರು? 21. No, no, no.
ಎಲ್ಲಿದು? I number ಏನದು?
ಒಂದ್ ನಿಮಿಷ ಇರಿ.
ಇದು
Plaintiff counsel is saying that even
that is correct.
21, Your Honor, my lords, she is not a party to the family at all.
ಇಲ್ಲ ಇಲ್ಲ.
21, no, illa, she is not the party to the family, joint family, or she is not a member at all.
Who is that respondent?
21, Muniyamma.
ಅದು ಇವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಬಟ್ ನನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದ್ದಿದ್ದು ಅವರು ಡಾಟರ್ ಆಫ್.
Bring them on record, please.
ಆಯ್ತು sir.
Where is your amendment application?
ಇಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. I have filed already.
All right, registry, counsel appearing for appellant
ಕಳ್ಸಿದ್ದೀನಿ.
in 15.1
ಇದನ್ನ
submits that an amendment application is filed, registry to place it on record by next
7
date of hearing.
Yes, ma'am. 7/20.
Amendment ಅದು?
ಹೌದೌದು, ಪರ್ಮಿಷನ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದೆ.
ಓ ಪರ್ಮಿಷನ್ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಹಾ.
ಎಲ್ಲ ಹೊಡೆದಕ್ಕೆ. Perused the amendment application filed in IS 7/24. You have any objection? Correction ಇದೆ ಅದು ಬರೇ. Since this
ನನಗೆ ಕಾಪಿ ರಿಸೀವ್ ಆಗಿಲ್ಲ.
ಬಿಡ್ರಿ ಮೇಡಮ್, ಏನ್ ಮಾಡ್ತೀರಾ ಕಾಪಿ ತಗೊಂಡು? Since in the amendment application, appellant is seeking correction of the name of
ಸಾಕಮ್ಮ ಬದಲು ಪೂಜಮ್ಮ ಬದಲು.
respondent number ಯಾರು?
21.
Respondent number 21 indicating that is wrongly reflected as so and so. ಈಗೇನೇ ಇರೋದು. However, on perusal of plaint, this court has noticed that it is wrongly typed as
ಸಾಕಮ್ಮ instead of ಪೂಜಮ್ಮ.
Sakama instead of
ಪೂಜಮ್ಮ.
Pujamma. Accepting the reasons, the amendment application is allowed.
Yes.
Appellant shall carry out necessary amendment in the cost item.
Subject to that, if she is a family member, it can be allowed, my lords.
ಇಲ್ಲ ನಾನು ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ
ನಾನು
sir, ಮುನಿಯಮ್ಮ
family
ಅಂತ.
ಹಾಕ್ತೀನಿ.
ಹಾಕಿದ್ದೀನಿ.
ಅವ್ರ ಬ್ರಾಂಚ್ ರೀ. ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ ಇರಿ. ನೀವ್ ಯಾರಿಗೆ?
ಇವ್ರು
And for the appellant in 492, my lords.
plaintiff appellant my lord.
Correct.
She is here now.
Yes.
ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಎಲ್ಲೋ ಐತೆ ಅವ್ರದ್ದು.
ಅದ್ರಲ್ಲಿ ಅವರೇ 7J ಅಂತ ಹೇಳಿ ಮುನಿಯಮ್ಮ ಅಂತ ತೋರಿಸಿದಾರೆ.
Madam, it will not affect your right. She represent a branch of, ಯಾರದು respond number 21 ಎಲ್ಲಿ ಬರ್ತಾರ ಅವರು?
21 ಬಂದು 7J my lord.
7J.
Mental, 7J.
Oh, 7J, ಮುನಿಯಮ್ಮ.
ಮುನಿಯಮ್ಮ.
Correct, ಅದು ದೊಡ್ಡ ಪೂಜಾಮನ್ ಬ್ರಾಂಚ್, ನಿಮ್
ಹೌದು,
ಬ್ರಾಂಚ್ ಅದು.
ಹೌದು,
You will see.
ಹೌದು.
That will not affect your share. So you have no locus to challenge.
ಅಲ್ಲ ಅವರೇ ಪಾರ್ಟಿ ಮಾಡಿ ಮತ್ತೆ ಇಲ್ಲ ಅಂತ ಇದಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ, but anyway, it doesn't
Yeah, it
affect.
doesn't affect her. It
They
doesn't.
have no locus to challenge that amendment application. Yes. ಸುರಣ್ಣವ್ರೆ, ಗುರುವಾರ.
ಗುರುವಾರ.
Yes, sir.
ಗುರುವಾರ ಪಾಠ ಹೊರಡು. ಪಾಠ ಹೊರಡು.
Number 16, Gangadhar Raitar. Gangadhar Raitar.
ಶುಗರ್ ಜಾಸ್ತಿ ಆಗಿ ಜಾರ್ ಬಿದ್ಬಿಟ್ಟು ಕಾಲು ಫ್ರಾಕ್ಚರ್ ಆಗಿದೆ.
ಆ?
ಶುಗರ್ ಹೈ ಆಗ್ಬಿಟ್ಟು ಮನೇಲಿ ಜಾರಿ ಬಿದ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಉಳುಕ್ಬಿಟ್ಟಿದೆ ಕಾಲು, ಹಂಗಾಗಿ ಓಡಕ್ ಆಗ್ತಾರ ಸರ್.
ನೀವು ಬೇರೆ ಲಾಯರ್ ಎಂಗೇಜ್ ಮಾಡ್ಬೇಕು. 2003 ಮ್ಯಾಟರ್ ಇದು.
ಒಂದ್ಸರಿ ಟ್ರೈ ಮಾಡಿ ಸರ್, ನೆಕ್ಸ್ಟ್ ಟೈಮ್.
ಈ ಲಾಸ್ಟ್ ಡೇಟ್ ಟು ಡೇಟ್ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ರೇನ್ರಿ? ಕೊಡಲ್ಲ ಇವತ್ತು.
ರೀಚ್ ಆಗಿಲ್ಲ ಸರ್, ಬಂದಿದ್ದು ರೀಚ್ ಆಗಿಲ್ಲ.
ಯಾರು? ಜಿ ನಟರಾಜ್ ಯಾರು? ಏನ್ರಿ ಇಂಜೆಕ್ಷನ್ ಸೂಟ ಇದು?
ಸ್ವಲ್ಪ ಇಂಜೆಕ್ಷನ್ ಅದು ಸರ್ಟನ್ ಇಶ್ಯೂ ಮೇಲೆ ರಿಮೈಂಡ್ ಆಗಿತ್ತು. ಸರ್ಟನ್ ಇಶ್ಯೂ ಮೇಲೆ ರಿಮೈಂಡ್ ಆಗಿತ್ತು. Remind in the sense, not the file was kept here. Findings were directed by the title court to be recorded.
Who are you? Dependent of plaintiff?
Plaintiff, I am the plaintiff.
Your suit is decreed.
My suit is decreed.
2003.
2003.
He wants time, he says his lawyer is not keeping well. 2003 matter. But could at the request of counsel for appellant list it on so and so date. Next.
Number 17.
ಏನ್ರಿ ಸಂಪತ್ ಅವರೇ, ಕೋರ್ಟಿಗೆ ಬರಲ್ಲಲ್ರಿ ನಮ್ಮ ಕೋರ್ಟಿಗೆ?
I'm sorry. I am for the respondent now.
And who are these appellants?
The appellants have abandoned. They don't want to appear. It was argued so many times before other judges. Of course, I am for the respondent. Now I have to sustain the order in my favor, impugned order. This is a suit for partition, my lord.
Appellants have not engaged the counsel. There is no reproduction of the appellant by way. And now DNP ಅಂತೂ ಮಾಡಲ್ಲ. It will not help your cause. But can we decide it in absence of appellant ಈಗ ಏನಿದು?
This is a little, even
Right
for,
time.
for your lordship's information, even my party is also not responding. But it's my duty. I can't retire.
It appears either they have settled or appellants have accepted the decree.
That's for 2000.
What happened to the final decree? Final decree later.
Final degree proceedings ಹಾಕಿದಾರಂತೆ. But still when I
ಇಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲಿ
Interim order ಇದೆಯಾ?
interim order drawing up a final degree ಅಂತ.
ಅದನ್ನು ವೆಕೆಟ್ ಮಾಡಿಬಿಡೋಣ ಈಗ. And we'll direct FDP court to expedite and draw final decree within 6 months. Suit ಯಾವ ವರ್ಷದ್ದು? ಇದೇ 2003 appeal.
ಹೌದು, appeal 1993.
2005, 1993 suit.
Even my party is not responding, my lord, but that's how you ಕೋರ್ಟಿಗೆ ಬರೋಲ್ಲ ನಾನ್ ರೆಸ್ಪಾಂಡೆಂಟ್
They
ಇದ್ರೆ.
are justified in not responding. They have a benefit of a decree. Why they should respond?
That's correct. But
Appellants are not-
I'm obliged to appear before this order.
All right, I don't dismiss for non-prosecution, but we'll dismiss it. And I'm being told that this is not the first time. It was dismissed twice, it appears. Yes, sorry.
ಇದು argument.
What is the defense? What is the defense?
That's not the issue for now. The parties are governed by Aliya Santanalo. Admittedly, there is no dispute. So the share determined by the, I am for the plaintiff, 4/7 share has been given. There is nothing wrong in this. And the first defendant who filed written statement did not even step into the witness box.
Not stepped into witness box. And this appeal is pending since 2003.
Yes, yes.
What was the defense actually?
They, in the written statement, what they contended that it was his self-acquired property. Land reforms, land reforms order, though the form number 7 would disclose that it was an ancient tenancy. That's what they contend. And the contest is by my brother, my lord, ultimately.
ಅಲ್ಲ ನೀವು ಎಷ್ಟು ಡೇಟ್ ಹೋಗಿದೆ actually?
issue number 8 and 9 at page 45, internal page. ಅದರಲ್ಲಿ clear ಆಗೋದು.
Page
45 internal page, judgment. Issues 8 and 9. Now issues your lordship will get at page 14, internal page 14. There is an admitted in during the evidence, joint aliya Santana family is admitted. The share determined is also correct. Now that has been discussed at issue 8 number 8 and 9. May I read, Mala? Page 45.
issue number 3. And what is this will that is set up by other
Yes,
defendants?
he has not tried to prove. In fact, my lord, that
None of the defendants have stepped into the witness box, sir.
the contesting defendant, but my brother, that is Vanaja Shetty's brother, Shekhar Shetty. Now, if your lordship sees the plaint, original plaint.
Who is Shekhar Shetty now?
Shekhar Shetty is the brother of the first plaintiff. He claimed the first. Now, I will just point out, my lord, one Sankamma Shetty.
All right, but he has not filed an appeal.
No,
Shekhar Shetty has not filed an
not
appeal.
filed.
This appeal is only by Allah's of first defendant, correct?
First defendant, yes, first defendant, Ramana Shetty. He did not even step into the witness box.
He can't maintain this appeal, correct? Akaya Shetty, yaru Akaya Shetty yaru.
Even reasonings, the only thing there was actually argument before other judges about the applicability of Aliya Santana law. So that fact is very clear, having regard to section 4 of the Hindu Succession Act. If it is inconsistent, any provisions of law, if it is inconsistent with the provisions of the Hindu Succession Act, then only it will run out of. Otherwise, it is very much applicable, and that judgment, this honorable court in the division bench in Madras Aliya Santana, how it is applicable, paragraph 24. ಅದು ಒಂದೇ ಇದ್ದದು contest.
ಎಲ್ಲಿ ಅದ್ರ ಮೇಲೆ issue ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ.
There is no issue on that point.
No, because when they earlier Vipin Hegde was appearing, then he retired.
All the cases, it's their self-accusation. They are not
One is that it was a Chalgani holding, individual Chalgani, Ramana Shetty. Form number 7 itself makes it clear that he was minor then.
Minor.
Yes, that aspect. And existence of Aliya Santana is admitted in clear terms in during the course of evidence.
That is admitted.
Admitted very clearly.
ಅಲ್ಲ ಹಳೆ ಸಂತಾನ ಇದ್ರೆ ಏನು? ಯಾಕೆ ಮಕ್ಕಳಿಗೆ ಬರಲ್ಲ?
ಹಳೆಯ ಸಂತಾನ ಅಂದ್ರೆ what happens, the female heirs now love for this one Sankama Shetty is original. She was the
Family tree ilva? Family tree illa.
But I'll make it clear. Sankama Shetty, she had 3 children. One is Paddaka, this one Ramana Shetty, who is the appellant, LRs of Ramana Shetty, and Mahabal Shetty. So in fact, my lord, when the inheritance as per Aliya Santana law, this Paddaka Shetty's female heirs, they will take per capita share. Now, for example, in this, my lord, Paddaka's daughter is Vanaja, and Vanaja, her children will get the shares. That's how Aliya Santana, this thing. The female heirs, they will inherit the property. The male heir, once it stops, it is a Nissantati Kavaru as per the Aliya Santana Act.
You know?
Nissantati Kavaru. The female heir, so long as her female children continue, they will get the shares.
Correct.
Now, for example, now there is Paddaka Sankama Shetty has one daughter and son. Son's children will not get any share as per the Aliya Santana. Daughter's children, even daughter, till
son will get a share.
Pardon me,
Son will
get one share. And the daughter one share, and her children will get that is per capita. For example, in this, that is 4/7 is how it is determined is then Ramana Shetty 1 share, Mahabal Shetty, they are the male heirs, so they have 1 share. And this Vanaja Shetty, she has 3 children.
Correct.
So that 4 shares, that is 4/7 share.
They will take independently.
ಈ ಮಾವನಿಗೆ ಒಂದೇ ಶೇರು. So
ಅಂದ್ರೆ ಅದು 1 unit ಅಂತ.
ಹೌದು, per capita.
That is taken as 1 unit.
1 unit. The female line will continue.
Oh, son, ಈಗ suppose Adesantan kagade, property is held by
Female.
a female.
She
died.
has 3 children, let us say.
One son and one daughter.
One daughter. Son will get one
Half
share.
share. Half share.
Half share. No, how it will.
Not half.
No, daughter, suppose let us in the same, suppose please say one daughter and one son. The daughter has 3 children.
Will presume
So
she has-
4 plus he allow 1. That is how it is. The female line of succession. Here for
next in generation is also included.
yes. The daughter, so long as that's what, till the female becomes 50-year-old. Then she will not have santati or continuation of santati. That is called nisantati kavaru in this. Now, so far as son is concerned, it stops there. But daughter's daughter, it will go on. That's
Followed.
that is it. That's very clear under the Aliya Santan Act. Now, the only question is that whether the Aliya Santan Act would still prevail in the district of South Kerala. That would prevail because Section 4(2) of the
Saves, sir.
yes,
Saves.
inconsistent. And there is a judgment of recent. There were so many.
Ajit Shetty also gave me 2 judgments.
This is the latest judgment which holds a will which has taken into consideration. No, I heard it. Sorry. I think paragraph I have written 24. It's a
All right, ಈಗ that son ಅಲ್ಲ, son ಗೆ ಒಂದು allot ಆಗತ್ತಲ್ಲ, 1/4 share. After his death, it will go to his ಯಾರಿಗೆ?
that's what, that is section 7(2) of the Hindu society. If it is an undivided interest, supposing there is no partition in the family, that undivided interest would devolve upon his personal heirs. That is what section 77.
The 1/4 will be redistributed among all.
Among his heirs, personal heirs.
All right.
Once it is allotted, it would be inherited by his wife and children.
ಅಲ್ಲಿ ಮತ್ತೆ ನೀವು section ಹಿಂದೂ
There is one more in Aliya Santan concept. There is called reversion clause. That is, a male sometimes will be given only life interest.
Correct, same.
It's
a reversal inheritance.
Reversal, correct. So that is why section 7(2) of the Hindu Succession Act, it is a case of notional partition. Supposing there is an undivided share which has not been allotted to him.
No, one more question. That 1/4 share which goes to the son, after his death, it will go on to the legal heirs.
Yes.
But Aliya Santana is not applicable.
Once he allotted, he becomes the absolute owner. So far as that is concerned. Correct.
Their succession
supposing in
succession under Hindu.
Under the Hindu succession. That's what section 7(2) says.
Ali section 8.
The same.
Section
just like that. It would, that what it 7(2) says, in such a case, it would devolve upon the personal heirs, not as per the Aliya Santana.
Correct.
That 7(2), where a Hindu to whom the Aliya Santana law would have applied if this act had not been passed, right after the commencement of this act, having at the time of his or her death as undivided interest in the property of a kutumba or a kavaru, as the case may be, his or her interest in the property shall devolve by testamentary or intestate succession, as the case may be, under this act and not according to Aliya Santana. Atara alli hogudilla, female. That stops. If it is only undivided, supposing in the partition, there is life interest idre,
followed.
It would revert back to the kutumba.
ಬರ್ಕೊಡ್ರಿ. ಹೆಸರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಏನು ಹೆಸರು ಡೀಲ್ ತೆಗೆದಿದೆ. The captioned regular first appeal is filed by legal heirs of defendant number 1, assailing the judgmental decree rendered by the court below in drawing a preliminary decree and granting joint to 4/7 share to plaintiffs 1-4. Next paragraph. In the suit, the original defendant number 1 appeared. Defendant number 1 appeared and contested. Sampath sir?
Yes. No, they have filed a written statement, but
defendant number 1 appeared.
Yes.
Defendant number 1 appeared and took a contention that social properties are his self-acquired properties.
Allotted by the land tribunal.
And since land tribunal has granted acquaintance rights in his individual capacity, these properties are not available for partition. after death of defendant number one, legal heirs of defendant number one have contested the suit, but strangely have not chosen to step into the witness box. Defendants having failed to mount the witness box and in absence of rebuttal evidence, trial court has decreed the suit
One more aspect.
by holding, yes, sir.
DW1 is examined. Who DW1 is none other than my brother. That is Vanaja said. What he said that first defendant had executed a will in his favor. That will, nothing is proved. That's all.
Correct.
And admittedly, Aliya Santana, applicability of the family is admitted fact. Very clear.
It is also it is also evidence from the records that the parties to the suit have unequivocally admitted that
They are governed by Aliya Santana.
that they are governed by Aliya Santana law. Next, in absence of contest by legal heirs of defendant number one, this captioned appeal cannot be kept pending indefinitely. The counsel on record has retired from the case. This matter was adjourned to enable the appellants to engage a counsel. No efforts are made by the appellants herein to engage a lawyer. It seems the appellants have lost interest in prosecuting this appeal, and therefore this court is of the view that no purpose will be served in keeping this appeal pending, more particularly in the light of the fact that the appellants herein have not let in any rebuttal evidence to substantiate that suit properties are self-acquired property of Ramnath Shetty. In that view of the matter, appeal is dismissed for non-prosecution by imposing a cost of 10,000.
And proceedings and FDP.
The
proceed.
plaintiffs are at liberty to proceed with the final decree proceedings.
Yep. Obliged.
The FDP court is called upon, shall expedite, since the suit is of the year 1993. Shall expedite and pass final decree.
Yes.
For 18, Kumar. It's separately. What will?
My lord, RFA 641 of 2009 is the comprehensive suit. Adala records bandilla. Records are required.
ಏನಾಯ್ತು?
Records ಬಂದಿಲ್ಲ ಅದರಲ್ಲಿ.
ಬೇಡ ನಮಗೆ ರೆಕಾರ್ಡ್ಸ್. ನೀವ್ ಹೇಳ್ರಿ.
ಮಚ್.
ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅದಿನ್ನು ನೋಟಿಸ್ IM ಹೋಗಿತ್ತು. ನೋಟಿಸ್ IA ಹೋಗಿತ್ತು, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಪೋಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಏನ್ರಿ ಜ್ವಾಲಕಮ್ಮ 2005 ಮ್ಯಾಟರ್?
ಆ ಮ್ಯಾಟರ್
you have come well prepared to seek adjournment.
ಇಲ್ಲ, not for that, my lord. This is the main appeal. If this is disposed of, all the other force will be follows it.
Then you argue, no?
My lord, the suit is for declaration and.
Suit is for what?
Suit is for declaration. To declare that the sale deed executed by the first defendant.
The lead appeal is 1964, according to you. Lead appeal is 1964.
No, 641 of 2019.
ಯಾವುದು?
641 of 2019 is the.
641.
ಹೌದು. ಉಳಿದಿದ್ದ 4 ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ಸ್ ಅದು.
Or 641. All right, ತಗೊಳ್ರಿ, ಆ ಫೈಲ್ ತಗೊಳ್ರಿ. ಡಿಲೇ ಆಫ್ 476 days. ಯಾರು ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, ಅದು ಮಾಡ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡಿದೆ, ಯಾರು ಮಾಡ್ಲಿಲ್ಲ.
ನೋಡೋಣ. ಬರ್ಕೊಡ್ರಿ. There is no contest to the application filed in I-1 of 2019. There is delay of 476 days in filing the captioned appeal. Bearing in mind that the captioned appeal is a regular first appeal filed under section 96. This court, being a final fact-finding authority, has to reassess the evidence, the oral and documentary evidence independently. In the interest of justice, this court deems it fit to condone the delay, inordinate delay, subject to payment of 1,000 rupees to clerk's fund. Yes, I heard. In matter. Who are you?
I am the plaintiff. Plaintiff suit. My lord, originally plaintiff has filed a suit against defendants 1 and 2 because defendant 1 has executed a power of based on power of attorney, executed a sale deed in favor of second defendant.
So who are related to defendant number 1?
They are strangers to me, my lord.
Strangers, sir?
Yes, sir. ಅದೇನಾಯ್ತಂದ್ರೆ earlier ಒಂದು ಮಂಜುನಾಥೇಶ್ವರ cooperative society for whom they have obtained an agreement as well as the power of attorney. making use of that power of attorney, the first defendant has executed a sale deed in favor of the second defendant independently. That sale deed I have challenged before in the filing the suit. In the proceedings, the defendants 1 and 2 contains that they have farmed the site and sold it to several persons. I have implemented all those persons, my lord.
All that, read issue, finding on issue number 1 and additional issue number 1.
Yes, before it, why I am selling it. Defendants 1 and 2 have compromised the matter, agreeing that the sale deed is not binding on them. Or compromise I think before the trial court. Only the contesting defendants are the subsequent purchasers of 4 sites.
Correct.
ಅದಕ್ಕೆ ನಾನು ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗತ್ತೆ ಅಂತ ಹೇಳಿ.
ಯಾಕೆ records?
Because compromise
they can't, they are having sold, they lose competence. They can compromise to the remaining properties which are not sold by.
What the sale deed executed by first defendant in favor of the second defendant, they concede it, my lord. They concede that the sale deed is.
How they can concede having alienated the property? Now there is the issue on purchases also, no? Whether defendants 22 to 27 prove that they have purchased the sites formed in by second defendant and respective purchases are in possession of the respective sites.
That is, the findings of the court is on 3 grounds, my lord. One is on limitation aspect, and since I have not.
You are able to settle the matter, you are able to settle amicably with the second defendant.
Yes.
You are able to retrieve some properties based on that compromise.
Yes, my lord.
What is left out is only 4 sites, correct?
Only 4 sites, my lord.
But, why this greed? He has already alienated, he has washed off his hands.
I have not tell you there is that.
We'll protect transferees, we have to protect. Idu nimdu collusive compromise idu. Contest ಮಾಡಿ ಅಲ್ಲಿ ಸೇಲ್ ಮಾಡಿ ನಿಮ್ ಜೊತೆ ಕಾಂಪ್ರಮೈಸ್ ಹೇಗೆ ಮಾಡ್ಕೊತಾರೆ ಅವರು?
That is the issue in what.
Already you read finding on issue number 1.
That's what. Monday ಹಾಕೊಂಡ್ಬಿಟ್ಟೆ ನಾನು.
Monday ಆಗಲ್ಲ. ಜಲಕುಮಾರ್ ಅವರು nothing doing. Read.
ಅಲ್ಲ ನಾನು I am not fully prepared, that's why.
ನಾವು ಇಲ್ಲ. Even I am not prepared. ಓದಿ. Read on issue number 1. Issue number 1 and I think additional issue number 1.
Yes, page 36, madam.
Yes, sir. Page 35, para 12.
Para 12, madam. From para 14.
Issue number 1 and 2, additional issue number 1.
Yes.
And additional issue number 1 and 2 dated already. Compromise ಆಗಿರ್ಲಿಲ್ಲ ಆದ್ರೆ things would have been different.
ಅದಕ್ಕೆ ನಾನು ಮಂಡ್ಯದ ಹಾಕೊಂಬಿಡಿ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ. I will look into that aspect.
Read. Jalakumar sir, read.
These issues are interlinked with each other in such a way that holding common discussion will not be put into any party in prejudice. It is pertaining to note that this court is required to pass judgment on merits against only defendants 7, 8, 14, 15, 22, and 27. As it is already stated, plaintiffs and defendants 1 to 3, 3 to 6, and 9 to 13, 16 to 21, 23 to 26 have arrived for settlement and entered into compromise. The crux of the matter is whether plaintiffs are able to prove that one K.C. Venkateshappa did not execute any general power of attorney in favor of defendant number 1. It is to be decided by this court. If so, whether the alleged sale deed executed by K.C. Venkateshappa through his general power of attorney in favor of defendant number 2 on 25/11/1991 is invalid and not binding on the plaintiffs. As far as relationship between K.C. Venkateshappa and present plaintiffs is concerned, the same is not in dispute. Admittedly, plaintiff number 1 is none other than the wife of K.C. Venkateshappa, whereas plaintiff number 2 is the daughter of K.C. Venkateshappa. Plaintiff number 1 is no more present and she left behind plaintiff number 2 as her only legal heir. During the pendency of the suit, the plaintiff number 1 is reported to be dead. Likewise, defendant number is no more at present. Legal representatives of defendant number 1 have sought brought on record. It is also not in dispute that survey number 94/1 measuring 1 acre 22 guntas and other properties were allotted to the share of K.C. Venkateshappa in the partition took place between K.C. Venkateshappa and brothers in the year 1969. According to plaintiffs, since K.C. Venkateshappa addicted to bad habits, alcohol, etc., practically the plaintiff number 1 was managing the family affairs. It is the specific contention of the plaintiffs that at no point of time K.C. Venkateshappa had executed any general power of attorney in favor of defendant number 1. Exhibit D2 is the alleged general power of attorney said to have been executed by K.C. Venkateshappa in favor of defendant number 1, B.R. Nagaraj Gupta on 27/1989. On the other hand, contested defendants relied on this general power of attorney. On perusal of the Exhibit D2, it discloses that K.C. Venkateshappa had executed this general power of attorney in favor of disease number 1 before Notary Public, Bangalore. I have gone through the terms and conditions of Exhibit D2. There is a recital to the effect that this power of attorney is an irrevocable power of attorney. As per the conditions number 19, K.C. Venkateshappa had received a sum of rupees 1,50,000 only in full settlement of entire cost of scheduled property. Scheduled property is none other than survey number 94/1 measuring 1 acre 22 guntas situated at Amrutahalli village. On the overall assessment of Exhibit D2, it can be stated that K.C. Venkateshappa had executed this power of attorney in favor of B.R. Nagaraj Gupta to manage the suit scheduled property, including the sale, mortgage, etc. Now, the question for consideration is whether an amount of rupees 1,50,000 can be treated as consideration of this transaction. General power of attorney is governed by provisions of law agency and provisions of Power of Attorney Act. In the present case on hand, K.C. Venkateshappa being the principal executed this power of attorney in favor of Sri B.R. Nagaraj Gupta as agent. It is settled principle of law that by virtue of general power of attorney, whether it is revocable or revocable, title cannot be transferred in favor of agent. Whatever the act done by the agent is on behalf of the principal, and the same is binding on the principal. Exhibit D3 is the affidavit said to have been sworn by K.C. Venkateshappa and plaintiff number 2. As it is already stated, plaintiff number 2 is none other than daughter of K.C. Venkateshappa. It is pertaining to note that plaintiff number 2, Jayalakshmi, had signed to general power of attorney as witness. General power of attorney bears a signature on every page. As per affidavit, it disclosed that payments have been made by B.R. Nagaraj Gupta in favor of K.C. Venkateshappa on different dates. It is further disclosed that by virtue of this affidavit, possession of the suit scheduled property has been delivered in favor of defendant number 1. When the title cannot be transferred by virtue of general power of attorney in favor of agent, it cannot be held that by virtue of affidavit possession has been delivered in favor of agent. The agent holds the possession of the principal to manage the property. It does not mean that agent is in possession of the property of the principal. It is if in an irrevocable power of attorney, only interest is created, but not a title is transferred. However, the fact remains that K.C. Venkateshappa had executed a general power of attorney in favor of B.R. Nagaraj Gupta. Whatever the amount has been shown in the general power of attorney is not relevant and cannot be considered as sale transaction. Apart from this, the possession of agent is on behalf of the principal. That being the position, taking into consideration the relationship between the principal and the agent, but by virtue of affidavit, possession cannot be delivered. However, Exhibit D2 is admissible only to the extent that K.C. Venkateshappa had executed the valid general power of attorney in favor of K.R. Nagaraj Gupta. Lord, here, so far as I have executed the power of attorney in favor of Nagaraj Gupta. It is only a notary.
That goes against you. Plaintiff number 2 is a signatory to the GPA.
Yes, ma'am.
And she doesn't step into the witness box. You tell me why adverse inference should not be drawn against her under 114G. She says she is disputing the GPA and she's a consenting witness. And she doesn't mount the witness box. She examines her husband. He lacks competence. And you have denied effective cross-examination. That opportunity is lost. The purchasers are left stranded high and dry, isn't it? And you enter into compromise with contesting defendants 1 and 2.
There is the only.
Yake, why you didn't step into the witness box? To tell me how your husband is competent. Was he present when the GPA was executed? When she signed the GPA? On each page. Our cross hag madidare, adar mele madidara. You lack competence anta another cross examination idea. Purchasers.
Let me look into that.
You complete this reading and then we'll examine. Odi, munde odi.
Exhibit P8 is the certificate copy of the sale deed dated 25/11/1991, whereas Exhibit D4 is the original sale deed dated 25/11/1991. Husband of plaintiff number 2 as power of attorney holder entered into witness box and he was examined as PW1. I have gone through the oral testimony of PW1. PW2 is one of the witness examined on the side of the plaintiffs. Now the question of consideration is whether plaintiffs had knowledge of execution of general power of attorney in favor of defendant number 1, K.C. Venkateshappa on 22/1989. During the course of arguments, advocate for contesting defendant submitted that plaintiffs have the knowledge of executing general power of attorney as well as sale deed dated 25/11/1991 by defendant number 1 in favor of defendant number 2. As it is already referred, Exhibit D2 is the original general power of attorney said to have been executed by K.C. Venkateshappa in favor of defendant number 1. It is pertinent to note that plaintiff number 2, being the daughter of K.C. Venkateshappa, had put her signature on every page. It can be noticed that Exhibit D2 came to be executed on 22/1989. In other words, it is certain that plaintiff number 2 had the knowledge of executing general power of attorney in favor of defendant number 1 by her father in the year 1989 itself. This suit came to be filed in the year 1997. As per the plaintiff arguments, K.C. Venkateshappa had addicted to bad habits like consuming alcohol, etc. It is further stated that under these circumstances, plaintiff number 1, being his wife, looked after family affairs. If that is the situation, it can be presumed that plaintiff number 1 had also knowledge of general power of attorney in favor of defendant number 1 in the year 1989 itself. By way of amendment to the plaintiff, some facts were introduced. It is stated that K.C. Venkateshappa had entered into an agreement of sale with Sri Manjunatha House Building Cooperative Society. During the course of evidence, BW1, by producing the copy of agreement of sale, tried to establish that this fact. Exhibit P12 is the certified copy of the agreement of sale dated 5/10/1985 in favor of Sri Manjunatha House Building Cooperative Society Limited. Of course, some payments can be looked into on the perusal of Exhibit P12, which disclosed that K.C. Venkateshappa had executed an agreement of sale with Sri Manjunatha House Building Cooperative Society Limited with respect to suit schedule property. It is not known what happened to this agreement of sale. There is a material to show that government had published preliminary notification to acquire lands situated at Amruthalli village, including the suit schedule property. There is material to show that Sri Manjunatha House Building Cooperative Society Limited filed 2 writ petitions so it disclosed that said society has questioned the acquisition proceedings in these writ petitions. It is pertinent to note that respondent number 4 in WP so is shown as, and the name of defined number as 2 has been entered in the record of rights. It is a contention of the contesting defendants that depend of layout plan obtained from the competent authority. It is a private layout. There is material to show that revenue authorities initiated action against defendant number 2 for violation of section 79 and 80 of Karnataka Land Reforms Act. Some of the defendants, but not plaintiffs, challenged the action of Karnataka Appellate Tribunal. There is material to show that Appellate Tribunal remanded the matter before the Assistant Commissioner Bangalore North for inquiry. It can be noticed that Assistant Commissioner, after holding inquiry, dropped the proceedings initiated against defendant number 2. It can be informed that if at all plaintiffs were in possession of suit schedule properties, noticing nothing was prevented to challenge these proceedings before the Karnataka Appellate Tribunal. It indicates that plaintiffs were not in possession of the suit schedule property and even much earlier to the date of filing of suit. Absolutely, there is no evidence to show that plaintiffs were in possession of the suit schedule property as on the date of filing of the suit. RTC were not standing in the name of plaintiffs as on the date of filing of suit. Plaintiffs failed to produce any land revenue receipts for having paid the land revenues to the government as on the date of filing of the suit. On the other hand, there is a sale deed to show that title has been transferred in the name of defendant number 2 by virtue of sale deed dated 25/11/1991. There is material to show that defendant number 2 formed a layout in the said suit schedule property and sold different sites in favor of different vendees. Of course, it is a private layout formed in the suit schedule property without obtaining any layout plan from the competent authority. But fact remains that vendees were in possession of the different sites and undertaken to construct the building in the different sites. That being the position, how could it be possible to hold that plaintiffs were in possession of the suit schedule property as on the date of filing of the suit? It can be noticed that during the pendency of the suit, the defendants 3 to 7 were impleaded as necessary parties. Admittedly, defendants 3 to 7 are different site holders from defendant number 2. It is not in dispute that plaintiffs had entered into compromise with defendants 1 to 3 to 6, 9 to 13, 16 to 21, and 23 to 26. Now, the question for consideration is whether any recitals in the compromise petition can be considered as admission as against the plaintiffs. As far as this aspect is concerned, it is more relevant to refer section 23 of the Evidence Act, which reads as under section 23. In civil cases, no admission is relevant if it is made either upon the express condition that evidence is of it is not to be given, or under circumstances from which the court can infer that the parties agreed together that evidence is of that should not be given. Two conditions are to be fulfilled in order to attract section 23 of the Evidence Act. Namely, if an admission is made by a party upon the express condition that evidence of such admission should not be given, or if an admission is made under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. Peruse the terms and conditions of compromise entered into between the some defendants and plaintiffs. There is no express condition that recitals of this compromise shall not be used as against other defendants. Moreover, the evidence of compromise petition cannot be read as in isolation with case against the contesting defendants. As far as compromise petition is concerned, the plaintiffs have duly admitted formation of different sites, including the sites of these defendants in a scheduled property. A scheduled property is none other than survey number 94/1 measuring 1 acre 22 guntas situated at Amrutahalli village. Of course, some of the defendants enter into compromise with plaintiffs subject to execution of confirmation deed by paying 3 lakhs each to the by the defendants. When the terms of the compromise petition cannot be read as in isolation with sites purchased by the contesting defendants, it can be used as admission by the plaintiffs against these defendants also. Normally, negotiations held in the settlement cannot be used as evidence against a party. In other words, it is without prejudice to rights of the parties. But in the present case on hand, there is no such condition either expressly or impliedly barred to use evidence of compromise against the other defendants. Taking into consideration all these aspects, one thing is very clear that much before filing of the suit, different sites were formed in the suit scheduled property, and defendant number 2 sold different sites in favor of various vendors. In the light of above discussions, it is not possible to give findings in favor of plaintiffs. Accordingly, I answer issue number 1 and 2 in negative, and additional issue number so in affirmative, and additional number issue 1 and 2 is negative. Well, insofar as findings aspect is concerned, well,
you questioned the GPA. Have you sought a declaration questioning the GPA?
That GPA not only sale deed has been cancelled.
Then how? Without questioning the GPA, how we could have maintained a suit seeking declaration, seeking cancellation of sale deeds without questioning GPA? All right, appeal admitted Monday. Registry to secure records telephonically Monday. I think we're lucky to get back some property.
Some
major property.
Because what I have
Have succeeded. Partially have succeeded also.
The only thing, the title remains with the plaintiffs because what I have executed in favor of Panchanatha House Building Society. In turn, they have defendants 1 and 2.
KC Venkatesh entered into an agreement to sell with some housing society.
Yes, my lord.
Here also he took money. Here parallelly.
The same money, my lord, that what I have received.
Under GPA, it is actually trial court has not properly appreciated. It is coupled with interest. GPA is coupled with interest.
That is a point.
That finding is wrong.
Even the title also not properly appreciated.
You conclude your arguments on Monday. Yes, sir. Monday 2:30, sir. Jalakumar. Registry to secure records telephonically. Appeal admitted, filing of paper book dispensed. Yes, sir.
My lord, serial number 39, my lord. 39, 2 weeks time, my lord. For R2, appellant counsel I have informed, my lord. Appellant is senior counsel is engaged. Senior counsel.
Is the body. One step.
After. Sir.
ಸರ್ ನಿನ್ನೆ ಬಂದಿದ್ದ ನಿಮ್ದು
ಇವತ್ತಿದೆ 34 ಸೀರಿಯಲ್ 34. ನಿನ್ನೆ ಯಾವ್ದು ನಿನ್ನೆ ಯಾವ್ದು ಬೇರೆ ಇತ್ತು ಅದು
ಬೇರೆ ಬೇರೆ ರೀಚ್ ಆಗಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಮಧ್ಯಾಹ್ನ ಆ ಮ್ಯಾಟ್ ನಡೆಯುತ್ತೆ. ಯಾವ್ದನ್ನ ಒಂದೇ ಎರಡು ತಗೊಂತಾರೆ ಅಷ್ಟೇ, 34ರವರೆಗೂ ಹೋಗಲ್ಲ ಅನ್ಸುತ್ತೆ. ಇದೆ 2:15 ಅದೊಂದು ಅರ್ಧ ಗಂಟೆ ನಡೆಯುತ್ತೆ. ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಯಾವ್ದನ್ನ ತಗೊಂತಾರೆ. ಅದೇ ಆ ಮ್ಯಾಟ್ರ್ ಆದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಇದ್ರೆ ಒಳ್ಳೇದಲ್ವಾ ಸರ್? ಐ ವಿಲ್ ಬಿ ಅರೌಂಡ್. ಇದ್ರೆ ಒಳ್ಳೇದು. ನಾನು 34 ಇದೆ. ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ಮನೆಗೆ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಏನ್ ಮಾಡೋದು? ಇಲ್ಲ ಕೂತ್ಕೊಳ್ತೀನಿ.
ನೆನ್ನೆದು ಏನಾಯ್ತು ಸರ್?
ಇಲ್ಲ ಅವರು 8
ತುಂಬಾ ಅರ್ಥ ಇದ್ದೀರಲ್ಲ.
ಅಲ್ಲ ಅವರು 8 lakhs ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ
10 lakhs ಕೇಳಿದ್ರು.
10 lakhs ಕೇಳ್ತಾರೆ. 5 ಹೇಳಿದ್ರು ನನಗೆ, ನಾನೇ 3 ರೇಸ್ ಮಾಡಿದೆ.
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ 8 lakhs ಅಂತ ಇದೆ.
ಹೌದೌದು, ಅಲ್ಲ ನಾನೇ ಹೇಳಿದ್ದು. ಅವರು ನಮ್ಮ ಪಾರ್ಟಿ 5 ಹೇಳಿದ್ರು, ನಾನೇ 3ಕ್ಕೆ ರೇಸ್ ಮಾಡಿದೆ. ಮತ್ತೆ
Pattern. Fine. Just giving the case.
Pass on the case details.
Yes. Yes. Great. ಅಲ್ಲ ಅದು ಮೆಮೊ ಮೆಮೊನು ಮೂವ್ ಮಾಡಿದ್ವಿ ಮೆಮೊ ಆಲ್ಸೋ
I think date is assigned.
ಪ್ಲೀಸ್
In fact, date was assigned on the previous day.
yes 11th was the date assigned date
Yes.
it was
We'll
not
look at it. We'll look.
yes as your lordships
We'll be closing this roster now.
great
We have our own.
great
There are too many parted matters.
please even that
We'll see how,
please
whether it can be accommodated next week, we'll examine it. And when
this
date will be
Saturday is a
Saturday, brother.
working
Next week we'll list it.
great
We'll assign a date on it.
please or appellant.
Appeal is dismissed.
Much obliged.
Appeal is dismissed. I'll rather read two paragraphs and then I'll pronounce the final order. Remanding the matter for a fresh inquiry would not only be redundant, but would also further exacerbate the parties' prolonged litigation. Given that land in question has been consistently identified as a non-tenanted and no form number 7 is pending against petition number 1, further investigation would be futile. The respondents have admitted that Manjappa Pujari was cultivating share of petition number 1 based on an oral partition, further complicating the tenancy claim by respondent number 3. This underscores the inherent flaws in the claim that respondent number 3 is a tenant of the disputed land. The fundamental issue that form number 7 filed by respondent number 3 is against his father, Manjappa Pujari, concerning ancestral property. This approach is legally and factually unsound because tenancy claims cannot be substantiated against a parent for a property that is part of a registered partition and already allocated to others. Therefore, any attempt to remand the case would only prolong the legal dispute without addressing the core issues, ultimately aggravating the parties' difficulties. Given the procedural and substantive errors in the land tribunal decision, the appropriate course of action is to quash the erroneous order and resolve the matter based on the established legal facts. For the foregoing reasons, repetition is allowed, impugned order is set aside. ಅದು ರಿಜಿಸ್ಟರ್ಡ್ ಅಲ್ಲಲ್ಲ ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಅದು ಓರಲ್ ಪಾರ್ಟಿಷನ್ ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಅದು
ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ದೇ ಆರ್ ಆಲ್ಸೋ ಅಡ್ಮಿಟ್ ದಟ್
Yes, madam. I will quash those. On the, I had asked you, there is no pension scheme, alla illi. ಏನು ಇಲ್ಲ pension ಇಲ್ಲ. It's not a pensionable, alla. All right. A repetition is allowed. Impugned order penalty of compulsory retirement dated so and so passed by respondent number 3, wide annexure T. And the order dated 9/4/2012 passed by respondent 2, wide annexure T1 are hereby quashed. Management is directed to expunge all adverse remarks related to the allegations from the petitioner service record. ಇದಕ್ಕೆ ಇದು ಒಂದು ಸ್ವಲ್ಪ we have to add up. You didn't hear me out when I was pronouncing, madam. Management is directed to expunge all adverse remarks ಅಂತ ಬರೆದಿದ್ದೀನಿ. ಅದಕ್ಕೂ ಮುಂಚೆ ಒಂದು since petitioner has superannuated, management is directed ಅಂತಂದ್ರೆ ಸಾಕು. ಬರ್ಕೊಳ್ಳಿ. The fact that petitioner has superannuated, comma, the management is directed to expunge all adverse remarks related to the allegations from the petitioner's service record. Petition is allowed. Respondents are directed to take into consideration the service certificate issued to the petitioner as per Annex B and the recommendation made by respondent number 3 as evidence filed in Annex F. Respondent shall consider petitioner for absorption into a permanent possession in accordance with the applicable laws and regulations. Entire exercise of considering petitioner for absorption shall be completed within a period of 3 months from the date of receipt of certified copy of this.
Matter. My.
Yes. Correct. ಮಾಡ್ಬೋದಲ್ಲ ತಾವು ಇವತ್ತು I'll hear you today. ಅದನ್ನ I'll hear you. Okay, all right. Yes, sir. Your appellant in RFA number?
I am the defendant number 5 in the trial court.
Your D5.
First appeal, first 969 of 2014. Fifth defendant was died subsequently. LRs of fifth defendant came on record. They were the appellants before this court. First appeal 969 of 2014.
Defendant number 5.
Defendant number 5.
You also failed to contest.
So I have cross-examined to the PW3.
Cross-examined.
Yes, yes. PW3. So wherein there are 2 points made. He has admitted that I have sold the property in favor of others. So through a sale deed dated 1959, 3419 video in respect of only one survey number, 3 acres. Survey number 55 of out of 4 survey numbers. So we have purchased from the father of the plaintiffs, that is Subrayappa. So during 1946, subsequently 1959, we have sold in favor of others. That is, the sale deed dated 34/1959. So the 3 acres in respect of survey number 55 itself out of 21 acres. So subsequently, we have also sold in favor of others. So they have farmed the layout and now they have.
This is admitted by plaintiff in evidence.
Yes, madam. So the plaintiff have admitted that we have sold the property and they have farmed the sites and the subsequent site owners have put up their constructions. The documents as well as subsequent possessory holders have not made the parties before the trial court. So only this point made. So now purchased and sold it. So we have no role now. So because he has filing the suit for declaration.
You have not retained any portion. You have sold entire.
The entire 3 acres, only 3 acres.
You have only purchased 3 acres.
3 acres.
And you have sold entire.
Sold the entire property through a sale deed dated 34/1959.
Then why you maintain this appeal?
So appeal is subsequent purchasers have not made the parties. And the cross-examination adduced to the PW3 has not been illustrated in any of the while passing the judgment.
Mr. Reddy, then why you have filed this appeal?
So file is because of my client's pressure, we have filed it.
Your clients felt like filing one appeal.
File it. So only that much I have.
Pradeep.
Basing on their title,
basing on their title, many of the purchasers are here before this honorable court.
Correct.
By way of the judgment, even their sale deed, though they have sold, is now declared as fraud and colorable document.
DeFi sale deed is held to be fraudulent.
Yes, they have paid consideration.
Without there being challenged to defendant fine number 5.
They need no one need not know. The question is to whether the plaintiff has a title or not. It is not with respect to a defendant has a title or not. That is not the question before this honorable court or before the trial court. Irrespective of the defendant's title, whether they have retained or they have sold, they do not have any interest today.
Yes.
Or whether their clients have just asked them to file. Now, basing on their title, several of them are here, and their sale deed is now held to be fraudulent.
So he can maintain.
Yes.
Yes, Sumashankar, nimdenu? You are impleading applicant ಯಾವ appeal ಅಲ್ಲಿ?
In our appeal, they have got impleaded.
1840 serial number, item number?
343.
ಅಲ್ಲ item number ಯಾವ್ದದು? 18. 1.3.
1.3. 1.3 minute. Three 43.
Three 43 ಅಲ್ಲ? These applications are allowed?
Allowed.
Yes.
But in this case,
You are tracing your title through whom?
my lord, we are the site owners. Nearly, my lord, from 2006 to 2024 purchase ಮಾಡಿದ್ದಾರೆ. We don't know, my lord, who has formed the suit item number is converted in the year 2006. And sites have been formed. And my lord, the impeding applicant respondents are fourth purchasers.
Fourth purchase.
Not parties to the suit. Our vendors are also not parties to the suit.
Which is that portion which is converted now?
Site number 4, my lord. Suit item number 4.
Suit item number 4.
Suit item number 4. 57. Survey number 57.
Conversion order in 2006, huh?
6, madam. 21-2-2006 ಕನ್ವರ್ಷನ್ ಆಗಿದೆ.
21-2-2006. You are the owner of site number?
Madam, along with the impeding application, my lord. Impeding application.
Code 343 code. ಅದು impeding application. Yes, sir.
Page 10 of the application, my lord. DM Ramakrishna is the first applicant. And the second applicant is Ganesh Aital, Anantaram Holla, Vasu, Shashikala, Akash Priyadarshi, and Bhagyalakshmi. Those are the. They've explained from para 14, my lord. Respective sites purchased by them, and the construction is also put up by them in some of the properties. Para 2, my lord.
Para 2 of?
Para 2 of, page 14, my lord. Para
Page
2, 14. I submit that I have purchased the site bearing number east to west 58 feet, north south 15 to 15 feet, totally measuring 887 square feet, 81 square feet, numbered as BBMP Kata number. But in all these cases, unnecessary. All these cases, BBMP has granted Kata, and I produced all the documents of title, and also PID number is also there. And tax paid receipts I have produced. But why I filed the impeding application, my lord? By taking, my lord, we are not parties to the execution also. But one fine morning, they came to our spot to evict us, man. Evict us. These are, my lord, some of the employees are, my lord, 4th degree employees in High Court. Installment alli tagondidare, avaru bandu ache. It is coming TV9. Ivurella allige odovodru. Immediately I filed impeding application. That is the question, my lord. Only to safeguard my interest in the suit schedule, item number 4, I came on record, my lord. But one more thing, my lord. Now, my learned friend, my lord, Pradeep, has substantially covered all the points, my lord. You have not left anything. On question of limitation, on appreciation of both oral and documentary evidence, and even in the absence of pleadings, and the documents of title and possession are not produced by the plaintiff before the trial court. One more question, my lord. Suit is also barred under section 3. He has also argued that point also. But court has to take judicial cognizance, even if the written statement has not been filed, suit cannot be decreed. Therefore, suit is barred under section 3 of the Limitation Act. One more, madam. Last time, before arguing the case before another bench, they have pleaded the delay in filing the appeals, delay in prosecuting these applications and appeals by the respondents and impleading by the appellants and responding. In the matter where immovable property is involved, Supreme Court has condoned 22 years in condoning in filing the first appeals. Second judgment, my lord, just I will.
Allah, you are an impeding applicant, Allah. You are arguing for appellant.
Ade ನಾವು actually appeal ಹಾಕಬೇಕಾಯಿತು ಬೇಡ ಅಂತ ಹೇಳಿ.
You are an impeding applicant.
Impeding applicant means actually ನಾವು appeal ಹಾಕಬೇಕಾಯಿತು ಬೇಡ ಅಂತ. We are not unnecessary. Just only 5 minutes, my lord. Citation, Kote. Civil appeal number 7878 of 2009.
Yes, sir.
Relevant paras. Paras 29, 28 I will read, my lord. 28, 30 and 31, my lord. Very relevant.
You have cited how many judgments? 2 judgments.
2 judgments. One is, my lord, relating to delay. It is not necessary.
Yes.
30, my lord. You kindly take 30 minutes. Para 30.
30 of which judgment? First
30 of the judgment, my lord. Justice Sanjeev Khanna and Justice J.K. Maheshwari.
Paragraph 30.
Yes, my lord. Para 30. Para 30. In the above factual background, for the plaintiff to succeed, she has to establish that she has a legal title to the Schedule A property, and consequently, he is entitled to a decree for possession. Defendant cannot be dispossessed unless the plaintiff has established a better title and right over the A Schedule property. A person the person in possession of land in the assumed character as the owner and exercising peacefully and ordinary rights of ownership has a legal right against the entire world except the rightful owner. A decree for possession cannot be passed in favor of the plaintiff on the ground that defendant number 1 to 12 have not been able to fully establish their right, title, and interest in the A Schedule property. The defendants being in possession would be entitled to protect and save their possession unless the person who seeks to dispossess them has a better legal right in the form of ownership or entitlement to possession. The burden of proof to establish the title in the present case lies upon the plaintiff, as the burden lies on the party who asserts the existence of a particular state of things on the basis of which she claims relief. This is mandated in terms of Section 101 of the Evidence Act, which states that the burden of proving of fact rests with the party who substantially asserts in the affirmative and not on the party which is denying it. This rule may not be universal and has exceptions, but in the factual background of the present case, general principle is applicable. In terms of Section 102 of the Evidence Act, if both the parties fail to adduce, the suit must fail. The onus of proof no doubt shifts, and the shifting is a continuous process in the evaluation of evidence. But this happens when a suit for title and possession, the plaintiff has been able to create a high degree of probability to shift the onus on the defendant. In the absence of such evidence, the burden of proof lies on the plaintiff and can be discharged only when he is able to prove title. The weakness of the defendant cannot be a justification to decree a suit. The plaintiff could have succeeded in respect of scheduled property if she had discharged the burden of proof through the title of the scheduled property, and which squarely falls on her. This would be the true effect of Section 101 and 102 of the Evidence Act. Therefore, it follows that the plaintiff should have satisfied and discharged the burden under the provisions of Evidence Act, failing which the suit would be liable to be dismissed.
Like this judgment may not be applicable to.
Question is, my lord.
Umashankar, ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಪ್ಲೈ ಆಗಲ್ರಿ.
ಅಲ್ಲ, ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂತಂದ್ರೆ even the defendants are placed ex parte. All defendants are not entered appearance. Even the defendants are not filed written statement. The question is, my lord, it is for the plaintiff to establish his title.
No, they are the owners.
And the suit
No, they were the owners at one point of time. Whether they could have maintained this declaratory suit by selectively withholding material facts.
that is one thing. That is one thing. Throughout the process.
Can they overcome all subsequent transactions without questioning 1946 sale?
Correct, my lord. To show that they have exercised the ownership, possession. No documentary evidence is before.
No, they are the owners unless they are able to challenge the alienations. Question is whether they can maintain a suit for declaration without questioning the alienation.
Yes, that is the.
Even a formal declaration to the effect that these sale deeds executed by our maternal uncle is not binding on us. Even that declaration is also.
Not sought, my lord. Not sought. Even that declaration has not been sought. My lord, to show on the date of suit, to show that they are in possession. My learned friend has already argued. Pradeep ಮಾಡಿದ್ದಾರೆ. ಏನು document ಇಲ್ಲ.
ಇಲ್ಲ, in the alternate now they have sought possession.
Yes, my lord. Maybe. My lord, possession is, my lord, possession. Their entitlement of possession based on the, my lord, they have to prove the fact we are in wrongful possession. That is the settled position of law.
And now there is a lot of variance in schedule now. They have filed a suit painting these lands as agricultural lands. They have undergone alterations.
They have filed a suit for agricultural land. Now, they get all BBMP kagas in their favor and they sell it.
Leftover lands,
Vacant land.
Which already there are acquired title. With respect to constructed portions, they are not able to.
Alienation made by them will be subject to outcome of these proceedings now. Appeal also.
So now, if that purchaser bids of construction, who has already purchased, then they will have to again file a civil suit.
Yes.
Written statement.
Date numbers are not matching. They now have a very different layout of their own. Other numbers. Even boundaries are not matching. And I am also not able to understand whether my clients who are now doing.
Oh, really? Our suit item number 4 has been converted in the year 2006. They have not brought to the notice of the court, my lord.
They have not?
Brought to the notice of the court. Trial court.
Not.
Please, my lord.
ನಾಳೆ tomorrow. ಇದು ಕೆಲಸ ಇಲ್ಲ ಆಕ್ಚುಲಿ. ನೀವು ಹೇಳ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು ನಾಳೆಗೆ. Tomorrow. 2:30, tomorrow 2:30. Pradeep, section 3 ಮೇಲೆ judgment ಅಲ್ಲಿ
ಇದೆ ಸರ್.
ಆಮೇಲೆ from plaint and plaint documents you have to substantiate that how section 3 is applicable. From the revenue records, from cross examination by defendant number 5. you should make out, you should be able to demonstrate that plaintiffs had knowledge of these alienations or constructive notice, because they are placed on record revenue records.
The revenue record there clear mention,
Yes, that you have to highlight.
And your lordship judgment is Swami. Registration of the sale deed is a public notice anta ತಾವು ಒಂದು ಯಾವುದು
ಹೌದಾ?
ಹೌದು ತಾವು ನಮ್ದೇ ಜಡ್ಜ್ಮೆಂಟ್. ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ದಿ ಸೇಲ್ ಡೀಡ್ಸ್ ಮೇಲೆ ನೋಟಿಸ್ ಟು ದಿ ಪಬ್ಲಿಕ್ ಅಂತ ತಾವು ಹೇಳಿದ್ದೀರಾ. ಅದು ಸೆಕ್ಷನ್ ಇದರಲ್ಲಿ ನೀವು ತಾವು ಮಾಡಿದ್ದೀರಾ ಸ್ವಾಮಿ.
Okay. Yes, madam. Where is your opponent? Who has engaged senior counsel? He has engaged a senior counsel. And this appeal is by whom, madam? Yeah, of course, suit will be always by the plaintiff. Defendant. Declaration.
Mother had filed a suit for declaration, declared her as owner of the property by virtue of a bill which had been executed by her husband.
Husband. Now, there is a finding that you are adopted, sir. What is that?
Also is valid. The grounds for appeal by the appellants here is on three grounds there is appeal here. One is with respect to the age of the adopted son is a question here. It is admitted that as per the Hindu Adoption Act, he has to be 15 years. But he case again so the adoption registered deed is registered when he's 17 years. But the document clearly mentions that he has been adopted when he was 1 year, custom practice and Madi, adopt Madi, the document itself clearly speaks. But documentation is done when he's 17 years. That is one point which has to be, which is the appeal point here. The second point.
What's the date of adoption?
Adoption date is 13/12/1992.
There is no issue on adoption.
There is an issue whether P2, who is the adopted son, whether is a necessary party on the issue matter. In that issue, entirely this question has been answered. That is the other point of appeal by the other side. Where issue, if there is no issue. I put in the citation.
Who is second plaintiff? All right, you appear for defendants. Plaintiff number 2. And this appeal is by whom? Defendants.
Sorry, my lords.
Yes, sir. Now, how they are related plaintiffs and defendants?
Originally, property belonged to one Chitta Lakshma Reddy.
Now, whether the defendants are related to you?
Then this is originally property belonged to one Chitta Lakshmana Reddy. He had 3 sons.
3 sons.
So Chitta Lakshmana, Chitta Somana and Dodda Lakshmi. Those 3 were the original owners.
Where's the family tree? You should always have your own family tree. No, it's don't, that's very wrong. You should draw a family tree on your own to narrate facts. You should have on green sheet, you should get it typed. Where is Lakshman Reddy?
So originally, Lordship, the last head where is the Chitta Lakshmi Reddy.
Yes.
So his wife is Rangama, who's the plaintiff number 1.
All right, now you represent the branch of second wife. Whether this marriage was post. Edne Henti Lakshmamma. Timmaya had 2 wives.
Under Lakshmama, Chitta Lakshmi, under Chitta Lakshmi, Rangama. Our father is Chitta Lakshmi. I am adopted by Rangama. I am adopted son of Rangama.
Now what is defendants?
But here, the 1 to 3 are great grandson of Chitta Soma. Defendant number 1 to 3 before the trial are grandson of Chitta Soma. These 3 to 6 are grandson of Chitta Soma. These 7 to 12 are grandson of Dodda Lakshmi.
All right, then core issue is additional issue number 1. Wait a minute. You should hear out when a judge is asking you a question. The core issue is additional issue number 1. Read additional issue number 1. They admit your title, they admit family partition. Only question is they say that your father has relinquished by executing a registered release deed. Whether such a document is there, how the trial court has dealt with this additional issue number 1? It's unregistered. That's all. They have to overcome this issue, finding on this issue. That's all.
Their question is the bill, he doesn't have any right to execute the bill in favor of his wife, is their question. And the other contention is.
They have, under what provision? Under what law a husband is barred from bequeathing his property to his wife?
They contend that no partition should happen between the brothers.
Even in absence of will, widow will succeed along with son.
Yes, sir.
That will not go to the defendants. Read finding on additional issue number 1. Where is the discussion on release deed? Right?
Page number 10 of the judgment. See, during his lifetime, Chikkalakshman Reddy has acquired his property under a registered will. So first place, about the I continue.
Directly come to release deed, madam.
In 1970, there is a release deed executed by Chikkalakshman Reddy, but it is an unregistered document and it cannot be looked into and it cannot even be believed that at a very young age, Chikkalakshman Reddy executes a release deed. After the death of Chikkalakshman Reddy, first plaintiff has adopted the second plaintiff and their adopted son, and the adoption is also proved. And after the death of Chikkalakshman Reddy, first plaintiff was in possession and enjoyment of the two property, and the plaintiff have become the absolute owner of the same. The learned counsel for defendants has argued that no partition has taken place in the family, and if really any partition has taken place, there should have been a document. But as per the Pavati Varasuda, Kata has been affected and unregistered documents produced to show that there is a partition. In respect of release deed, as it is an unregistered document, and he was a very young.
All right, and the partition between all sons, where it is discussed?
Also, the portion of the cross-examination has been attracted judgment.
Where?
Page number 15 of the.
This cross-examination, yardidu?
DW1, who is a co-defendant.
DW1. ನಾನು ಹಾಗೂ ಇತರ ಪ್ರತಿವಾದ ಜಮೀನು ಬೇರೆ ಬೇರೆ ಮಾಡಿಕೊಂಡು ಬೇರೆ ಬೇರೆಯಾಗಿ ವಾಸವಾಗಿದ್ದೇವೆ ಅಂದ್ರೆ ನಿಜ. ಬಾಯಿ ಮಾತಿಂದ ನಾವು ಬೇರೆ ಬೇರೆ ಇದ್ದೇವೆ ಎಂದು ಈ ಸಾಕ್ಷಿ ಸ್ವಚ್ಛಂದ ಹೇಳಿದ್ದೆ.
So the only contention of the defendant is that
Whether this partition is reported and reflected in revenue records?
it has been reflected orally. They have partitioned the property. Subsequently, portion was enjoyed by everyone. And what has been come to my mother from my husband, he has been enjoying the property for a very long time. And by virtue of the same, he has executed a will in my favor.
Yes, sir.
Kindly have it on Monday or Tuesday, my lord.
Tomorrow.
Please, ma'am.
Please, I'll hear you. Once, let the appellant counsel argue. You can argue. Nadi. Matladu. ಎಷ್ಟಿದೆ? ಹೌದಾ? ಯಾವ್ದದು ಸೀರಿಯಲ್ ನಂಬರ್? ಎಸ್ ಮೇಡಮ್.
Serial number 20, my lord.
Madam.
Is that serial number 20, my lord?
Serial number 20.
Yes, my lord. I have some doubts in my own preparation. I thought that I'm not fully equipped to assist this honorable court. The question involved is, my lord, agreement to sell is done. Plaintiff executes an agreement to sell. The defendant goes away to Dubai. He does not come back. My lord, he does not pay part payment also. No registration. So he files a suit, my lord, for injunction. By then he put up the construction. So he amends the plaint for declaration of title and for possession. Now the trial court comes to conclusion under his possession is safeguarded. He can take it as a defense and he need not vacate. This is the without any registration. So, my lord, I wanted to bring up whether any such thing could be done. How he can get the owner. My lord, that is why, my lord, I was looking for the case laws in this behalf. Well, I was surprised as to how he can get the title, my lord. I am entitled to title and I am entitled to get back the position. No registration. Admittedly, no registration. That's why, my lord, I was looking into some of three, but I am not fully satisfied to assist your lordship.
All
I
right.
wanted, well, I think your lordship would be in a position to give a, law has to be laid down in this behalf. I thought that this is the proper course, that's why I came to mention to your lordship. I'm examining, I think it requires consideration, my lord.
I'll give a date. I'll adjourn it. I'll fix a date.
Yes,
Fix
my
a
lord,
date.
I am also looking into it, my lord.
All right.
And- Yes, my
All
lord.
right, adjourn, adjourn.
Yes, yes, my lord.
What is it? Bill number 50.
Adjourn.
Sale number 50. ಈಗ ಎದಕ್ಕೆ ಬಂದ ಆರ್ಡರ್ಸ್ ಅಂತ ಯಾಕೆ ಬಂದಿದೆ ಇದು? ಹೌದಾ? ಆಯ್ತು, ಫಿಕ್ಸ್ ಇಟ್ immediately after vacation. ಇವನು ಅಷ್ಟೇ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್, immediately after vacation. Yes, sir.
In this case, we have filed the reply to their applications.
You have filed?
We have filed.
Reply?
Yes, Miller.
You appear for whom?
I am appearing for the index, Miller.
Index.
Please, Miller.
Let's fix a date. Next.
24?
Next.
Oblige. In this app, Miller, the order sheet, our appearance is not being marked, Miller, so.
Not marked.
Although 2 times the matter could not reach for hearing, now we have been coming from there.
You're not, your name is not reflected.
Miller, this has not been shown in the order, though the matter has also not reached for the hearing.
All right, we'll see you on the next day.
Please.
52. I-1 of 24 is filed, seeking leave of the court to produce, for production of additional documents. Statement of objection are filed. I-1 of 20. Oh, ada. Then better, what are the None appears, list it on. What do you after that? 53. Admitted for temporary injunction. All right, list it on so and so date. Yes, sir. 48, huh? Yeah, who is in appeal? 48, huh?
48, I'm for the respondent.
Yeah, defendants, brothers are in appeal.
Brothers are there. And they are the only contention saying that the certain properties which were purchased in the name of mother are self-occupied property. But the prior court or the other held that the properties which were in the name of the mother are also joint property. Now after the judgment, mother has a father. And now they are relying upon will.
Will is produced now.
Now,
That will be subject to finding on main matter
main. If it is held that it is a self-occupied property.
of mother and not available for partition, then probably will has to be considered. How the properties purchased in the name of mother can be treated as ancestral properties?
Ancestral property, there is in the cross-examination, there is a suggestion put in the year 1994, all the properties were partitioned between the father, mother and other children. And mother did not step into the witness box. She did not file any written statement. Written statement filed by son is allowed.
And what is the evidence to show that it was put into common hotspot?
There is suggestion by they did not prove the earlier.
No, you have filed a partition suit. asserting that what was purchased in the name of mother are also joint family ancestral properties, correct?
That is the contention hearing.
Huh?
To deny that, she did not even file written statement, only written statement.
Ali presumption barattala, property held by a Hindu female is her such.
But however, there is a suggestion
By
by the dependent number one.
that there,
Contesting dependent number one to one and.
that these properties were partitioned.
Earlier partition, there is a suggestion, father, mother and children.
Oh, and the property standing in the name of mother were also in subject matter of partition. ಒಂದೇ ವಾರದ ಈಗ ಕಲ್ಯಾಣ ಅದು ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಅದಕ್ಕೆ 2013 ಅಲ್ಲ ನಾವು ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ 2013. Yes, madam.
The Lordship, serial number 24.
24.
Final hearing matter. A date may be fixed.
Who is going to argue? You are your senior. Huh?
I'll argue.
You will argue.
Please.
Why your senior has not read the file? Huh?
He is, Your Lordship, he is held up in the other court hall.
The court.
Please.
2006 matter.
Please. It's a defendant's appeal. Suit for partition, specific performance.
Who are you plaintiff or defendant?
Defendant, Your Lordship.
What, you have denied the transaction or?
Your Lordship, we were not given the opportunity to contest. We've just filed the wakalat. And later on, we have not filed a written statement.
But madam, you have to examine the scope of 96(2).
Please, Your Lordship.
You cannot set up a defense that you are not heard. You can attack the judgment, saying that even in absence of defense,
please,
plaintiff can be non-suited, has to be non-suited.
Please.
You can question the findings.
Please.
You can't set up your defense in 96(2) appeal. You are ready?
Yes, Your Lordship.
Sadashivappa sir is not ready. The way is bala ದೂರ ನಿಂತು ಬಿಟ್ಟಿದ್ದಾರೆ. ಏನ್ರಿ sir? ಒಂದು ನಿಮಿಷ, I'm still not done. Yes, sir. No, we will not hear whether they were served or not. That recourse is not available under 96(2). They can question the findings, saying that even in absence of defense, you were not entitled for relief anta. Registered agreement. ಅಲ್ಲ ಯಾವ ವೆಂಡರ್ ಅಂದ್ರೆ ಅವ್ರು ಯಾರು? Oh, the children.
Subsequent to filing the appeal, the defendant appellant dies, Your Lordship.
You are ready, sir? Next week it can be. You want it to be taken or you want some time? Next Thursday. Next Thursday.
Please.
ಹೌದಾ?
The other one also dies subsequently, Your Lordship.
You have to tell, it is your family. I mean, you are better placed to tell who are the LRs who are left out. Huh?
My family member, Your Lordship. Mother and sons.
Oh, you are the agreement holder, correct?
Please, he is the agreement. Subsequent to filing the appeal, the other son also dies. There's only one legal heir. So we bought him on the record, Your Lordship.
Examine it next week. No. Correct. Yes, sir. Next Thursday. Yes, sir.
Oblige, Your Lordship.
Huh?
It's not more than 20 minutes. Doubtful title could be transferred to the purchaser for validity.
You have seal number 35. Cost is paid, sir. Cost is paid. Madidara. Counsel appearing for appellant has brought to the notice of this court that cost of 5,000 imposed by this court is made good. Office to verify. Office to verify. ಏನ್ matter, sir? Is money suit? Money decree?
Out of them. I doubtful right. was also paid some small amount. I was the guarantee. So I was because the purchaser, I should be joined. So we both executed the sale. So that sale is paid after the sale deed. And who wants to say that I have no right to transfer the property? It's covered with this.
Allah, the sale deed is in his favor now.
He doesn't, no. Sale deed, he doesn't want to attack. Seller, he wants to attack that. Purchaser is not attacking that.
The one who had joined you.
Yes.
He says that he had no right to sell it. I mean, you have no, but both together have joined. And you're party to the sale deed. No fraud is pleaded. Then how he is bound by the, cannot, he is bound by the recitals in the sale. Yes, sir, next week.
List number 45. Sir,
Next week.
list number 45.
Another. What, 27?
45
Serial
million.
number 34 million.
ರಾಜಶೇಖರಪ್ಪ ಸರ್ ಏನ್ರಿ
Respondent.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number 34 million.
ಹಾ.
This is a suit of 2000 and the appeal itself is of 2010 million. Why I succeeded before the trial court.
Both are injunction suit, ah?
Inactions.
All right. Yaar suit is decreed?
Suit is dismissal million. It is only, it is my property.
You are the defendant.
I am the, no, in one, yes, I am the defendant in the one suit filed by this persons who claimed injunction against me, contending that it is a road. But
And
it
what is the
a sale.
connected suit? What is the connected appeal about?
No, yes, they wanted to demolish the property belonging to me. I filed the suit against the corporation and also the.
Your suit is decreed.
My suit is decreed, other man's suit is.
All right, correct. Next week. Yes.
45 million.
Date
45.
on the court.
Next week, next Thursday and Friday.
45 million. 45 million. 45.
Next Friday, half day.
45. Well,
Other Thursday now.
Please go.
45 million.
Yes, sir. ಒಂದೇ ವಾರ ಉಳಿದಿರೋದು ಈಗ ಎಷ್ಟಾಗ್ಬೋದು? ಒಂದೇ ವಾರ. ಅಪೀಲ್ ಅಡ್ಮಿಟೆಡ್. ಪಾರ್ಟರ್ಡೆ ಜಾಸ್ತಿ ಇದೆ. ಆಗಲ್ಲ. Better pick up the dates immediately after vacation.
Well, 45 million.
Collect dates.
Court officer. Sir. Sir, court officer.